Hello? Don't hear you. Hello?
Hello, everyone. We will be starting momentarily, okay? The judge will be on the bench in just a few minutes.
All right, good afternoon, everyone. Thank you for your patience today.
Good afternoon.
Good afternoon.
No, please don't do that. Thank you. Everyone, please remain on mute. This is the State Expedited Accusations calendar in the State Court of Fulton County, Georgia. I'm Judge Melanie Williams. At this calendar today, we will address cases for those individuals who have been recently arrested, but the cases have already been formally accused and bound over to state court. All defendants, please pay close attention. You have certain rights today. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney today. As you can see, I am conducting this hearing by video. I am not there in person with you. That means any member of the public can log on and watch this particular proceeding. It's also being recorded. I see several members not appropriately dressed for this hearing. If you're wearing a bonnet or pajamas, please remove that and take a few minutes to conduct yourself appropriately. Or if you are in a store or driving, we will remove you from the Zoom and invite you back when you are in a secure location appropriate for court. All right, Ms. Bridgewater, what is my reset date?
Yes, Your Honor, it's going to be February the 3rd.
Thank you. Those who receive a signature bond will be reset further notice. Those who receive surety bonds or cash bonds at this calendar today will be reset to our February 3rd state all-purpose calendar, whereby aspects of the case, including bond and contact, can be revisited. Have all defense attorneys had the opportunity to interview their clients?
Yes, Your Honor. Good afternoon.
Good afternoon. All right. I'll assume, are there any other announcements at courtroom 2 before we begin?
No, ma'am.
All right, who do we have first?
Number 12, Mr. Douglas.
Thank you. Mr. Douglas, your case is 26 CR 000449B. In this case, you're charged with cruelty to children in the third and battery family violence. Do you understand your rights today? I'm going to assume that's a yes, Mr. Howard.
Yes, ma'am.
Second arrest, 2021 suspended license conviction, level 1.
Thank you. Whose case is this for the state? Ms. Evans Battle, please proceed.
Yes, Your Honor. As to Mr. Douglas' case, this incident happened on January the 20th of 2026. Officers went to 4001 Lakemont Drive, an apartment there, in reference to a domestic. Nakaya Seabrooks is the victim in the case, and they were waiting outside when the officers arrived. They indicated that they were arguing over snacks for their 3-year-old child. Mr. Douglas pushed her and threw her into a wall, causing holes in the sheetrock. She did fight back. The officer noted that she had several scratches and bruises around her neck and in her face, and her braids were pulled out as well. The child, JD, was also present when this took place. In that this is his first, we only have that prior driving without license. The bond recommendation is for a $5,000 signature bond through pretrial services level 1, that he start the FVIP program, have no further contact with Ms. Seabrooks, stay away from the location, and that that is broken down as to $1,500 for the cruelty and $3,500 for the battery family violence. No alcohol, drugs, or weapons while out on bond.
Okay. Is Ms. Seabrooks present, wishes to make a statement? I'm sounding for Ms. Seabrooks. Okay. Who represents this defendant?
I do, Your Honor.
All right, please proceed, Ms. McLeod.
Your Honor, my client has no record. He is 26 years old. He tells me that that he was not the primary aggressor in this instance. And I believe his story. He had marks on him when the officers arrived, according to the warrant. I also did check, and Miss Seabrooks has a fairly significant history, including where she pled guilty for first offender.
Miss McLeod, let's not, okay. Let's just do this, Miss McLeod. Do you object to a signature bond at level 1 through pretrial?
No, Your Honor, but I do object to the FVIP.
Okay, what about the stay away and no contact?
Well, this is his place. It's not her place.
Okay. Does the state have any information about where she resides, Miss Evans Battle?
I did note a different address, but there was some confusion because it indicated that the child lived there. So at this particular time, we do not have anything we haven't heard anything from Miss Seabrooks, so I can't.
Okay, understood.
verify.
All right, so what we're gonna do is, based on Ms. McLeod's representation to the court today, defendant is going to receive a $4,000 signature bond at level 1 through pretrial services, $3,000 on the battery, family violence, and $1,000 on the cruelty to children in the third. He is going to take the 1-day anger awareness course and have no contact with Ms. Seabrooks. I am not going to order the stay away based upon his attorney's representation to the court that is his location, his address. Additionally, he's to have no alcohol, no drugs, no weapons, and will be reset further notice. Is there anything additional?
Nothing further, Your Honor. And that concludes my business before the court today. May I be excused?
Yes, take care, Ms. McLeod. Have a wonderful afternoon. Bye-bye. All right, who do we have next? Are there private attorneys on the line?
Good morning. Oh, good afternoon, Judge.
All right, if private attorneys could do the raise hand feature if on the Zoom, if you don't mind, and let's try to take their cases first. Can we take Ms. Rockwell's case next, please?
Number 27, the Johns case.
Afternoon, Judge. Joseph on behalf of Mr. Najim. I'm here present in court.
Okay. Oh, well, let's take Ms. Rockwell, please hold. Can we take, I'm sorry, your name again, sir?
No problem.
It's Tosif Chauhan. Sorry, Ms. Rockwell.
No problem.
And who's your client?
Judge, it's position 27, Asmir Najim.
Okay, so we'll go ahead and take that case. All right, Mr. Nedrum, your case is 26 CR 0004222B. In this case, you're charged with simple assault, family violence, and criminal trespass. You understand your rights? All right, Mr. Howard.
Second, 2014 possession of marijuana. Wanted out of Peach County, level 1.
Thank you. All right, Ms. Evans Battle.
Yes, this incident occurred June 15th of 2024. The officer went to 12760 Etris, ETRIS Road in Roswell. They found that Mr. Nashim was arguing with his father, screaming and cursing him. His name is Sabreen, Sabreen, Nashim, and he's the victim in this case. He indicated that he was going to beat him up. There was other people in the home attempting to, I believe his mother was in the home, attempting to diffuse the situation, and he moved her out of the way. Our recommendation for bond is for $5,000 signature bond through pretrial services level 1, that he complete 3 anger awareness classes, have no further violent contact with Sabreen, Nashim, or other household members. That would be broken down into $2,500 for each count. No alcohol, drugs, or weapons while out on bond, Your Honor.
Thank you. Is Sabreen Najim present and wishes to make a statement before the court? Hearing none, counsel, do you have any objection to that signature bond with those conditions?
No objection, Judge.
Is there anything else you'd like to place on the record?
Nothing further, Judge.
Okay. Defendant will receive a $3,000 signature bond through pretrial services, 2,000 on count one and 1,000 on count two. He's to have no further violent contact with any member of his household, including the alleged victim in this case. He's going to take the 1-day anger awareness course and have no alcohol, drugs, weapons, and will be reset further notice. Is there anything additional from either the state or the defense as it pertains to this case?
Nothing as it pertains to Mr. Mr.
No, Your Honor.
All right, and counsel, does that conclude your business today?
It does, Your Honor. May I be excused?
Yes, you may. Take care. Have a wonderful afternoon. And please forgive my oversight in skipping over you there at the jail. All right, take care.
Hold on, say that again, I'm sorry.
No.
I'm sorry, say that again?
Oh, nothing. Unless we got 32, Ms. Redwood.
Okay. And is that Ms. Rockwell's case?
Yes, it is.
All right, Ms. Redwood, good afternoon. Your case is 26 CR 0000443J. You're charged with simple assault, family violence, and simple battery, family violence. Do you understand your rights today? Is that a yes? I'm going to assume so. Mr. Howard?
Second, 2017 driving while intoxicated. Conviction, level 1.
Thank you. Mr. Sirocco, good to see you. Please proceed.
Good to see you, Your Honor. This incident took place May 27th at 243 Oak Cliff Court, northwest in Atlanta. This was a dispute between roommates here. There are a number of roommates living at the location. The victim, Miss Michelle Adamson, explained that the defendant, her roommate there, lives with her there, had gotten into a dispute with her. She'd gotten very angry over how household issues were being handled. And Miss Adamson picked up her phone to record the argument. She, the defendant, was yelling at the victim to stop recording, or she was going to hurt her. Ultimately, approached her, had threatened to beat her, and had then slapped the phone that the victim was holding out of her hand. That video recording of the dispute was shown to the officer. Additionally, there was an independent witness who confirmed that the defendant had threatened Miss Adamson. We have spoken with Miss Adamson. She confirmed the events in the warrant. She said the defendant continued to harass and have altercations with her and other roommates since this incident. She's since moved out. The victim has since moved out. She's had enough with the defendant's behavior. She's asking for no further contact. And as she's moved out, a stay away is not necessary. The state, given the history here, is recommending a signature bond through pretrial services. We are recommending 2 days anger awareness, no further contact with Michelle Adamson, no drugs, weapons, or alcohol while out on bond. And if we could send for Miss Adamson, I believe I see her on the line.
Okay.
I'm sorry, what was your request?
1 second. Okay. Ms. Adamson, if you wish to make a statement, this is your opportunity. The statements are not required, but I'm going to give you some instructions. If you wish to make a statement, please unmute and raise your right hand. And you don't wish to make a statement. Okay, that's more than fine. Ms. Rockwell, do you object to the signature bond with those conditions?
Judge, does that mean pretrial she has to get, and the conditions are fine. We've already contacted a bonding company, et cetera, for a good bond. I didn't know, will she have to be reporting to pretrial and get permission to leave town, et cetera?
Yes, she would.
Does the court I heard one prior DUI from several years ago, 2017. Would the court be okay, since they don't live together anymore, would the court be okay with a $2,000 good bond and no contact?
You prefer to pay than to have the
Well,
signature bond, Ms. Rockwell?
Judge, those pretrial bonds get burdensome sometimes with before they can go out of town, and I have to file motions and get
Okay.
permission and all that.
Understood,
And we've
understood.
already contacted a bonding company, so.
Okay. All right, so in light of Ms. Rockwell's request, defendant is going to receive a $2,000 surety bond. It'll be $1,500 on the battery family violence and $500 on the simple assault family violence. She's to have no contact whatsoever with the alleged victim, last name Adamson in this case, whether via social media, text, call. She should not contact her in any manner. I am not going to order the stay away. She's to have no alcohol, no drugs, no weapons. And because she is receiving that, surety bond, her case will be reset to state all purpose on the 3rd of February. Ms. Rockwell or Mr. Sirocco, is there anything additional?
No, Your Honor.
All right, take care, Ms.
Thank you, Mr.
Rockwell.
Sirocco, and thank you so much, Your Honor. May I be excused?
Yes, you may. Take care
Thank
and
you.
best of luck to you, Ms. Rockwell. That concludes your case. Can we take Mr. Oles's case, please?
This is number 9, sure. Kaminsky. Wow.
All right, good afternoon, Mr. Kaminsky. Your case is 26 CR 000-438J. You're charged with violating a family violence protective order. Do you understand your rights today?
Yes.
All right, thank you. And I don't see, this is yours, Miss Evans Battle? I'm sorry, Mr. Howard, but then, okay. Yes,
6.
Mr. Howard.
6. You got an open battery DB, crew 10 and third, 2 counts. Simple battery. It's 25 CR 004-275J. You got an open ag stalking, 25 PI 007-033. Level 2.
All right, thank you, Miss Evans Battle.
Yes, Your Honor. As to the first violation, it occurred August the 21st of 2025. Between that period of time and September 24th of 2025, he violated the order in that there was and still is a protective order in place, which specifically indicated that he was not to interfere with her mail. And he
Her
did
mail, like the physical mail through the mailbox? Okay,
like
please
through the
continue.
mail, or in this particular case, he went to the post office and had them to stop and hold her mail, so it wasn't even coming to her house. And I know that during this period of time, he committed a new offense and was incarcerated. Once, I believe, when he was released is when they may have determined that that happened. Also, on the second case happened January the 6th of 2026, when an investigation occurred that on about December the 30th through the 12th of January of this year, that he had been seen in the area of her location. He has a company card that the victim indicated that she thought she saw. Her name is Megan Stubbs, by the way. And so she recorded the incident and then determined that the person actually driving the car was not his, but he do in fact have a car similar. They reached out to his employer to determine whether or not he had a car that was similar to that. As part of that investigation, they were able to confirm with the employer that he had admitted to him that he had been at the home on December the 30th of 2025, even though there is a protective order that specifically says that he has to stay away from the address at 1150 Clemington, spelled Kilmington Court. And he was, in fact, at that location. He admitted to the officer upon investigation that he was there to retrieve mail, although the witness would indicate he had informed him he was there checking on his car. And as part of that conversation with the officer, he did say he noticed that there were marks on his car. In either instance, he's under a protective order not to be there. It's my understanding his open cases that are here in Fulton County all revolve around the victim and the protective orders that are in place in which he are violating. The battery family violence that Mr. Howard indicated, there was originally a pretrial order in place for $5,000. He violated that order in August of 2025 and has the aggravated stalking case related, and that's the 25 PI 007033, in which a $10,000 surety bond, so that was, and the other bond was surrendered. So that's $15,000 out in a surety bond, is my understanding, as it is. Our position is he continues to violate not only the orders of court here, but also the orders involving the TPO that is in place. And we would ask the court to consider a cash bond in the amount of $10,000 for each count. Had this been, I believe there was some contact with the victim as well. Let me check regarding his incarceration.
Okay, I can, if you don't see it quickly, we
I
can
don't
just
see it right
agree that,
now.
okay.
All right, thank you.
All right, and anything else, Ms. Evans-Battle?
And of course, as part of any bond that he makes, we continue to say that he has to obey the order, no further violations of the law, no alcohol, drugs, and weapons, and stay away from the victim in compliance with the orders of protection.
Okay. Is Ms. Stubbs present and wishes to make a brief statement? If you are, please unmute your camera, raise your right hand. Okay. Mr. Oles? Mr. Oles, if you're speaking, we can't hear you.
Thank you, Judge. My apologies.
Okay.
My client's involvement with the legal system here has stemmed out of an incident that took place, of course, back in August. There were a couple of misdemeanor charges that were brought as a result of that. And Ms. Stubbs applied for a protective order. The ex parte order, unfortunately, was not served on my client. He was not aware of the hearing. He could not attend. A 12-month order was issued without his knowledge or ability to represent himself. And he only found out about that order days later, after it had already been entered, at which time it was a little bit too late for the birthday presents that he'd sent to his son. And he attempted to send to his son through a friend. And that has somehow mushroomed into where we are today. As far as the particulars of what's being alleged here today, it is true that my client tried to redirect his mail. I believe when we get to the evidentiary stage is going to show that, but that was blocked, and the only avenue left to him was to be able to go to the mail box location in the community, but that is geographically diverse from the house. It's not within the 2,000 or the 200-yard limit. And all he wanted to do was to pick up his mail because there was a credit card coming from his employer that he was responsible for. And out of that is come these present charges. My client is a father. He's lived here 8 years in Fulton County, 3 years at the current location with his family, with Mrs. Stubbs. And together they're the parents of 2 children, ages 8 and 1. Since the entry of the order at which he was not represented, my client has been trying to see his children. He's filed back in family violence court to try to amend the order in so that he can at least obtain his possessions. The issue with the car is that his car remains at the house. He can't even get it to drive to work, and he's been relying on the generosity of people since then in order to maintain his job, which is key because if he loses his job, he's the source of income for his entire family. And if he can't pay because he's in jail, they're going to go out on the street. And that's not really in anybody's best interest here, Judge. The allegations that I've heard here today have been regarding the mail and um, and the car, but certainly nothing that would arrange to was attempted contact with Miss Stubbs. My client has been scrupulous in complying with his obligations under the order. He has dutifully paid his child support every single month. He has dutifully attended his family violence classes. We and presented to me evidence of all those obligations being met. The initial charge that started all of this, of course, only came into existence because he was unaware of the existence of the order at the time he was alleged to have violated it. He has been doing his best to comply. I would say that my client is not a flight risk. He's lived here for 8 years. This is where his family is. He's just trying to get back into connection with his children, whom he loves dearly, and is continuing to do so. He's trying to do that through the family violence court. And if that's not possible, he's going to do what he has to do. He's not planning to go anywhere. He wants to keep his job, assuming that he can get out of jail in order to do that. But again, if he doesn't, he's going to lose that, and no one is going to be benefited by that. I think my client is very sincere in that he is intending to comply with the order after he learned about it, and that what has happened to this point, if the allegations are true, certainly did not represent any kind of a threat to Mrs. Stubbs. He has almost no criminal history in the past. He's not, he is full-time employed and serious about doing that. He's not intending to flee. To do so would mean abandoning his children. He's not going to do that. He's not a significant risk of harm to anyone on the outside, nor is he representing a significant risk of harm to Ms. Stubbs. So we're asking the court here today to grant my client a bond in such amount as he is able to afford, so that he can continue to work to support his children. He currently earns about $50,000 a year, which is pretty well absorbed with the cost of the house and his children, where they are currently. He's been bumming, living off friends in the meantime in order to keep that going. So, Your Honor, he has just a mountain of challenges ahead of him out of a situation that wasn't initially, as far as violating the order, wasn't initially of his making, but he finds himself in a very difficult situation for him. We would urge the court to set a bond in a reasonable amount that's going to allow him to continue to work and support his family, because otherwise they've got nothing. Thank you, Judge.
All right, thank you. All right,
Thank you, Judge. I was able to locate the note that I was looking for. It appears that someone gave the bonding company her telephone number and asked that she bond him out last night. And it's her belief, based on her having known him, that that was a way to indirectly reach out to her again. She indicated that both the attorneys were in court yesterday because he filed a motion to set aside the TPO and that the judge denied that motion. She's indicating that those multiple aggravated assault cases, again, are still pending under that in TPO, and she's really fearful for the safety of her and her children. Although Mr. Oates is saying that she's dependent upon the income, she wants no further contact at this time. She's fearful.
All right. Defendant is going to receive a $3,000 surety bond. He's to abide by the terms of the Family Violence Protective Order and have no contact with the alleged victim in this case, and stay away from that location regardless of whether his items are there. He's not to contact her through a third party, by the internet, phone, text, no contact whatsoever. Again, he's to have no alcohol, no drugs, no weapons, and he will be reset to all purpose on the 3rd. Is there anything additional from state or the defense?
No, Judge.
All right. Best of luck to all parties concerned. Mr. Olson, does that conclude your business today?
It does. Thank you, Judge. May I be
Take
released?
care. Yes, have a wonderful afternoon. Can we take Mr. Moran's case, please?
Yeah, absolutely.
Thank you, Your
Denizar?
Yes, Michael Denzard, that's right.
I'm sorry, what number is that?
11.
Thank you.
No problem.
All right, Mr. Denzard, your case is 26 CR 000-451A. In this case, you are charged with battery. Do you understand your rights today? Thank you. Mr. Howard?
First.
All right, thank you. Ms. Evans-Battle?
Yes, on January the 9th of 2026, the officers went to 1016 Howell Mill Road Northwest and spoke with the victim, Rosalind Bangura, Bangurah. And she indicated that her neighbor had sent a disturbing message to her. She went over to the neighbor's home, and that when she knocked on the door, Mr. Denizard opened the door and punched her in the face, started hitting her. Thereafter, Miss Madison also hit her, who was the neighbor she went to see. Another neighbor heard the commotion, came out and separated the parties, and Miss Bangura was bleeding from her face and from an ear. In light of this being his first incident with the law, the state's recommendation is for a $3,000 signature bond through pretrial services level 1. We would ask that he complete 3 anger management classes, have no further contact with the victim, Rosalind Bangura, and stay away from the apartment complex location at 1016 Howell Mill Road. My victim has indicated that she has lived there for 10 years, and I don't believe that he is a resident of that location. No alcohol, drugs, or weapons while out on bond. Thank you.
Is Rosalind Bangura on this Zoom conference and wishes to make a very brief statement?
I am here. I don't have
Wait.
to make a stick.
Okay, no statement. All right, thank you so much. Mr. Moran?
Yes, Your Honor. I'll start out with some biographical information. Mr. Denizard is 46 years old. This is his very first arrest in 46 years. Until recently, he was employed with in the entertainment industry with a company called International Local 479, which is through the Association of Theatrical Stage Employees. He was recently been out of work due to the Writers Guild strikes. He is a resident of I believe it's 1026 Howell Mill Road, the apartment complex. Mr. Denizard, his girlfriend, whose name is Madison Thomas, as well as I believe the alleged victim in this case, Miss Bangura, are all residents of different units in that apartment complex. So the very first thing I would ask is that the court not prohibit him from living at his own residence. He did not go over to Miss Bangura's unit. Miss Bangura and Mr. Denizard's girlfriend were having some back and forth on social media. And Miss Bangura went over to Mr. Denizard's girlfriend's house to confront her. And when Miss Madison, the girlfriend, opened the door, Miss Bangura, apparently from what Mr. Denizard and Madison Thomas have informed me, Miss Bangura attempted to force her way into the residence while screaming at the two of them. And Mr. Denizard and Miss Thomas were simply trying to keep her out of the residence. So they're vastly different stories on both sides of this. But again,
which we'll sort through another day, I'm sure.
Another day, yes, Your Honor.
Yeah. Mm-hmm.
But again, he was employed until just recently. He's attended some college, no prior criminal history. Due to him recently being out of work, I would ask the court for a UJR bond. Again, he has no problem having no contact with Miss Bangura. He has no desire to have any further contact with her. I would ask that Miss Bangura stay away from both of their units as well, and they'll do the same, and hopefully we can avoid any more issues like this. I would ask that the court not require him to do 3 anger management courses. At some point, this will get sorted out through the state court, and if it turns out to be a conviction, which I think is unlikely, he can do anger management at that point. But I don't think that would be appropriate here. I would ask for either a UJR bond, preferably, given his financial situation right now, or a low bond, as low as the court will consider.
Okay.
Just to go through the IALA factors, I don't believe he's a flight risk. He's never had an FTA or fleeing and eluding. No criminal history at all to speak of. He's not a risk of committing additional felonies. He's not a risk of intimidating the victim. Again, he has not approached Ms. Bangura or contacted her. This only happened because she was trying to force her way into Mr. Denizard's girlfriend's apartment. And finally, I don't believe he poses a risk of injury or damage or property, people or property in the community either.
Okay. All right. Defendant is going to receive a $3,000 signature bond at level 1 through pretrial services. He is to have absolutely no contact whatsoever with Ms. Bangura and stay away from her unit if possible, at least 1,000 feet. If that prevents him from his home, then I won't require it. However, if she's in a different building, he should just go to his unit, go right in, and that's it. No hanging out in the courtyard or any of that other stuff until this matter is resolved. I'm not going to require the 3 days of anger awareness, but I am going to require the 1 day of anger awareness, which is I think a 1 hour or 1 day course. He's to have no alcohol, no drugs, no weapons, and will be reset further notice. Ms. Bangura, I've sounded for you earlier. I asked if you wish to make a statement. We're not here to clarify the facts. If you wish to say something very, very briefly, please turn on your camera and raise your right hand and wait for instructions. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, ma'am, absolutely.
Okay, we're not here to discuss, so if you disagree with the facts as presented by either attorney, that's not what I'm interested in today. What we're most concerned with is desires for contact with the defendant. In light of those instructions, what would you like to tell me very briefly?
The only thing that I would request is that he is not allowed in building 2, as he is not a resident of building 2. He is a resident
Well,
of
you
building 2.
already heard my instructions that he stay away from you and go directly to his home. So I think we've covered that.
Wonderful.
Is there
Okay,
anything
thank you.
else? All right.
That's all.
And I don't mean to be brief, but we have a very large calendar and a lot
I
of people
understand.
to hear from today. All right. Thank you for coming to court. I appreciate you making that statement. Anything additional from the state or the defense?
Your Honor, if
No,
we
thank
could,
you.
I'd just like to clarify with Mr. Denizard what building and unit he is in. And then that'll be it.
Mr. Denizard, you can tell us, but again, he's to go right in, Mr. Moran, to his house, sit down, not hang out, so it doesn't really matter if it's next door to her or not. But let's go ahead. What building do you live in, Mr. Denizard?
3.
Okay, so don't go to building 2. Go even regardless, go into your house. That's it. Is there anything additional from the state or the defense at this time?
Thank you, Your Honor.
Your Honor.
All right, Mr. Moran, does that conclude your business today?
It does. Thank you. May I be excused?
Yes, you may. Take care. Have a wonderful afternoon. Best of luck to all parties concerned. This case is concluded for today. I did see Lucia was logged in. Can we take the interpretation case now? Were there any other private attorneys before we go to that? Okay. All right, Lucia, if you would unmute, turn your camera and raise your right hand.
Good afternoon, Your Honor.
Good afternoon. Please state your name for the record.
Lucia Urtuzastegui.
Ms. Artisatsuki, will you please, do you swear or affirm today that you'll make an accurate translation from English to Spanish, Spanish to English to the best of your skills, knowledge, and ability?
I do, Your Honor.
Thank you.
Could you tell me what is the case? Is this position one? I'm not sure who
I
I'm.
honestly don't know either. Who represents this defendant who needs interpretation?
I do, Your Honor. It is position one. I have spoken with him through the language line, but he needed support.
Okay, understand. I was just making sure you didn't need to do an interview.
No,
All right. Good afternoon, sir. Your case is 26 CR 0000419G. In this case, you're charged with giving false information, driving under the influence of alcohol, improper lane change, and driving without a license.
Buenas tardes, señor. Usted está aquí el día de hoy por el caso 26 CR000419G. Las acusaciones, los cargos en contra suya son dar información falsa a un oficial de la ley, conducir bajo la influencia del alcohol a capacidad disminuida, cambio de carril indebido o errático y conducir sin una licencia de conducir válida.
You have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you.
Usted tiene el derecho de permanecer en silencio. Todo lo que usted diga o cualquier cosa que usted diga puede y será usada en contra suyo.
You have a right to an attorney, and your attorney is present on this Zoom conference, Ms. Cook, to assist you with this proceeding today.
Usted tiene el derecho a tener un abogado. La señora Cook es su abogada del Estado, es la abogada defensora suya y está aquí representándolo el día de hoy.
And as you can see, I'm conducting this hearing by video. It's being live streamed, and any member of the public can log on and watch.
Y como usted puede ver, estoy haciendo esta audiencia por medio de video. Está abierta al público. Cualquier persona del público puede ingresar y puede ver.
Do you understand your rights and how I'm conducting the hearing today?
¿Entiende usted sus derechos y cómo cómo vamos a tener esta audiencia el día de hoy?
Can we unmute just for a moment at courtroom 2? You understand, sir?
¿Comprende usted, señor? Yes.
Thank you. Mr. Howard?
Muchas
Fifth
gracias.
arrest.
Ahora piden antecedentes. I'm sorry, Mr. Howard. Go ahead.
It's fifth arrest. 2024 illegal alien. 2016 driving without a valid license conviction. Level 1.
Okay, thank you.
Le indican que parte de sus antecedentes, este es el quinto arresto. En el 2024 lo arrestaron por estar en el país ilegalmente. En el 2016 por manejar sin licencia de conducir y fue encontrado culpable.
All right, Mr. Sirocco?
Ahora
Thank you,
el
Your Honor.
señor Sirocco, quien es, el fiscal de la oficina del fiscal.
I did want to supplement with his latest criminal history check. It does appear that he's wanted out of Tennessee for failure to appear from this past October, 2025.
Además, quiere él añadir parte de su historial penal que está usted siendo buscado por el estado de Tennessee porque no se presentó a una corte o a un citatorio que tenía de octubre del 2025.
This incident took place January 19th at Holcomb Bridge Road and Old Alabama Road, where those two roads meet in Roswell.
Este incidente por el que estamos aquí el día de hoy ocurrió el 19 de enero del 2026 en la intersección de las calles Holcomb Bridge Road y Old Alabama Road.
The officer observed a vehicle bearing a Tennessee tag crossing out of its lane of travel several times, and the officer proceeded to initiate a traffic stop.
Un agente de policía observó un vehículo con placas del estado de Tennessee, el cual estaba manejando, cruzando diferentes carriles de la carretera y observó esto varias ocasiones.
Did we lose Mrs. Sirocco? Oh no. Mrs. Sirocco, you still there? Okay. Miss Evans Battle, can you text him to see if he can come back again? He appears to be frozen.
Sorry about that, Your Honor. Can you hear me?
Yes, we can. We lost you for a moment, but please continue.
So strange. I could hear you talking, but I couldn't. I don't think you could hear me.
We
Um,
couldn't.
yes. The defendant initially identified himself falsely as David Hernandez, and also gave a false date of birth of April 20th, 1992.
Inicialmente el acusado y presentó o se identificó falsamente, dio el nombre de David Hernández con una fecha de nacimiento de abril 20 de 1992.
The officer noted that there was an odor of alcoholic beverages emanating from the defendant's person, and the defendant admitted that he consumed about 4 beers within the last hour or two.
El agente pudo oler un grande olor a cerveza y el acusado, el detenido, confirmó que había tomado 4 cervezas en la última hora.
Defendant agreed to complete standardized field sobriety testing, which he scored, from what I could see here, very poorly on.
El acusado también entonces accedió a dar una prueba de sobriedad en esos momentos, la cual los resultados fueron muy malos.
In addition to being all over the place with the tests, the officer observed that the defendant had red, bloodshot eyes, difficulty with balance, and difficulty following instructions throughout the investigation.
Durante la investigación, el agente de policía observó que no podía mantener su balance, su equilibrio, que tenía los ojos rojos y que no podía obedecer las instrucciones del agente de policía.
Defendant also stated he did not have any driver's license, and from the check that the officer ran, it appears he's never had a driver's license.
El acusado también dijo que no tenía una licencia de conducir y que basando en lo que la agente de policía pudo verificar el historial, parece que nunca ha tenido una licencia de conducir.
With his criminal history and with that wanted status, it appears out of Tennessee for failure to appear. There is a risk of flight as well as failure to appear. And with this behavior, this sort of conduct, he poses a risk to the broader community at large with driving under the influence.
Basándonos en el estado que está haciendo, que lo están buscando, en el estado de Tennessee, y con las acusaciones que confronta en este tribunal, piensa nuestra oficina que está a riesgo de que no se presente al tribunal y de que se dé a la fuga.
As such, the state's recommendation for bond is a $4,000 total surety, $2,500 on the DUI, and $500 on each of the remaining other charges.
De acuerdo a eso, la fiscalía lo que está proponiendo, sugiriendo, aconsejando es un bono de fianza asegurado por $4,000. Eso se divide de $2,500 por el cargo de manejar bajo la influencia de alcohol y $500 por cada uno de los otros cargos.
We are also recommending no driving and, of course, no drugs, weapons, or alcohol while out on bond, Your Honor.
Y también estamos recomendando que no puede conducir mientras está bajo fianza en absoluto y también obviamente no puede tener, poseer o usar drogas, armas o bebidas alcohólicas.
All right, thank you. Ms. Cook?
Okay, muchas gracias y ahora vamos a oír de su abogada defensora, la señora Cook.
Thank you, Your Honor. Mr. Valencia is 32 years old. He's been in Georgia for the last 4 months. He's currently employed at a Chinese restaurant, I believe it's Chef Wu, where he's been there for the last 3 months. He does have, it's my understanding, he does have family in the area. And I'll stop there for the interpreter.
Sí, su señoría, el señor tiene 32 años de edad, ha estado viviendo en el estado de Georgia por los últimos 4 meses. Trabaja en un restaurante chino que se llama Chef Wu y ha estado ahí por los últimos 3 meses. De lo que sé, tiene familia que viva aquí en el estado.
As far as the giving false information to law enforcement, I want to say generally he maintains his innocence, and that we're not going to necessarily dispute the facts here. But as far as the giving false information to the law enforcement, it is my understanding that at work he does go by the name that he gave the officer, which is David Alfonso Hernandez. And the reason for that is because is my understanding his boss is unable to pronounce his name, and so that's the name that they call him at and use all the time at work. So that's what he's known by. So there may have been a language barrier in communicating with the officers. Nevertheless, the report does say that in their affidavit for arrest. We will be asking the court for a UJR on these charges, and if not, that a very low reasonable bond. I do
Hold on. 1 second, Ms. Cook. I think Miss Lucia needs a moment.
Yes, ma'am.
En cuanto a la información que fue dada falsamente en esta acusación, obviamente él permanece diciendo que él es inocente, pero en cuanto a la información de su nombre, que dio el nombre de David Alfonso Hernández, lo que dice es que ese es el nombre bajo el cual se le conoce en el trabajo, principalmente porque su empleador no puede pronunciar su nombre correctamente. Entonces pensamos que fue más o menos una barrera de lenguaje o simplemente no se entendieron por el idioma. Lo que nosotros estamos pidiendo para estos cargos es un bono de fianza a UGR. I'm sorry, go ahead, Ms. Cook.
Yes, we will be asking for a UJR, a signature bond, and if not that, a very low surety bond. It's my understanding that his brother will be the person bonding him out, and that his job is still being held for him. He does have a reason to return to court to fight these allegations against him. He is employed. He does live here locally in Roswell, Georgia. So we believe that he will return to court. We don't believe he's a flight risk. Previously, he did live in Tennessee before he moved here to Georgia. But he has plans to stay and remain in Georgia, is my understanding.
Entonces estamos pidiendo un bono de fianza no asegurado únicamente con su firma. Pero si es que eso no es posible, estamos pidiendo un bono de fianza con un asegurado con una cantidad baja. De lo que entiendo es el hermano de él quien le va a ayudar con la fianza. El acusado, el detenido, tiene trabajo, su trabajo lo está esperando y aparte de eso vive aquí en Roswell y no pensamos que tiene un riesgo a fugarse, que no es un riesgo de fuga.
Nothing further.
Great. Defendant is going to receive a split bond as follows.
Entonces, el fallo de la juez es el siguiente. Va a tener una fianza dividida de la siguiente forma.
On the giving false information, it'll be a $250 signature bond to the jail.
El dar información falsa o falsificada va a ser una fianza de $250 bajo su firma por medio de la cárcel.
On the DUI, it'll be a $1,000 surety bond.
El manejar bajo la influencia de alcohol va a ser un bono de fianza de $1,000 asegurado.
On the driving improper lane change, it'll be a $250 signature bond through the jail.
I'm sorry, Your Honor, can you repeat the amount, please?
$250.
El por manejar cambiando de carril y de forma descuidada es una fianza por medio de la cárcel, nuevamente bajo su firma de $250.
And on the driving without a valid license, it'll be a $500 surety bond.
Y el manejar sin licencia de conducir es un bono de fianza asegurado por $500.
He's not to drive unless he has a valid license or permit.
parte de la orden judicial es que no puede conducir a menos que tenga una licencia de manejar o de conducir válida o un permiso de aprendizaje.
And he's to have no alcohol, no drugs, no weapons.
Y la orden también incluye no puede usar ni tener alcohol, drogas o armas.
Is there anything additional from the state or from the defense?
La juez pregunta si es que quiere añadir algo, tanto la fiscalía como la defensa.
No, Your
No,
Honor.
Your
Thank
Honor.
you.
All right, with that being said, that concludes your case for today. Best of luck to you, sir.
Y eso es todo, eso concluye su caso. Buena suerte, señor.
And Lucia, will you sound and see if anyone else needs your help before you go?
Yep. Damas y caballeros, si se encuentran arrestados en alguna sala y necesitan un intérprete en español, por favor, párese en este momento. Y si está en la llamada de Zoom por cualquier razón y necesita un intérprete en español, por favor, abra su cámara, su micrófono y déjeme saber.
All right, that being said, thank you, Lucia. Take care. Have a wonderful afternoon.
Thank you, Your Honor. You as well.
All right, bye-bye.
We got number 40, Ms. Williams.
All right, Ms. Williams, good afternoon. Your case is 26 CR 0000448Y. In this case, you are charged with simple battery family violence. You understand your rights today?
Yes.
All right, Mr. Howard.
Second, 2009 residential mortgage fraud first offender.
Thank you. Mr. Sirocco?
Thank you, Your Honor. This incident took place January 20th at 4900 Delano Road in South Fulton. That is an apartment complex. Officers made contact with the victim, Miss Alanea Stillwell. She explained that the defendant, her mother, had gotten in her face and pushed her head backwards. There was it's my understanding that the victim was staying there at the location. It's the defendant's house that Miss Williams allowed. Uh, excuse me. Miss Williams had allowed, yes, Miss Stillwell there to help them get back on their feet, at least according to Miss Williams. But there was an altercation over ongoing disrespect in the home. A door was ultimately removed, and there was a confrontation that ensued. She, we have not spoken with Miss Stillwell as of yet. We'll continue those efforts. Judge, in the interim, the state's recommendation is going to be a signature bond through pretrial. We are recommending 1 day of anger awareness, social worker visit for housing, because we are recommending a stay away as well as no further contact with Miss Stillwell, out of an abundance of caution with having not spoken with Miss Stillwell. No drugs, weapons, or alcohol while out on bond. And if we could sound for Miss Stillwell if she's online and wishes to speak.
All right, if Ms. Stillwell is present, wishes to make a statement, please unmute and please raise your right hand. Await further instructions. And I don't see anyone with that name. And that is her mother, Mr. Sirocco?
Yes, this was a mother-daughter dispute, Your
Okay.
Honor.
All right, Ms. Kim?
Yes, Your Honor. Miss Williams is actually 43 years old. She came to Georgia 2004. She's been a resident of Georgia for 21 years. She has 2 years of associate degree for psychology, Your Honor. She had a restaurant. She was a restaurant owner, and right now she also does a catering business. This is actually going to be a dual arrest. I believe there's another warrant out there for her daughter as well. My client has it's very obvious to see the clear stretch on her face. And my client was basically trying to protect grandbaby. There's her daughter's man who gave birth to, who is a father of the grandbaby. Three of them are basically living at my client's house. She does not want to file for eviction. For her to return to her own place. I believe they are trying to find a place themselves. We would like to request one-time law enforcement officer escort visit to retrieve personal belonging, or if he police officer verifies that she's no longer there, I want my client to be able to go back home. It is her house, and we would like to request for, we have no objection to signature on bond at all.
And Your Honor, I don't see that this is a dual arrest. I do see there's appears to be a warrant out for the defendant's boyfriend for actions he committed with during this altercation as well. But aside from that, I don't see this being a dual arrest, at least not from the information I have.
All right. Defendant is going to receive a $3,000 signature bond at level 1 through pretrial services. She's to have no further violent contact with the alleged victim and have no alcohol, drugs, or weapons. And I did say 2-day. She's going to do the 2-day anger awareness. And her case will be reset further notice. Is there anything additional? All right. Best of luck to all parties concerned. Who do we have next?
Yeah.
Position number 7, Ms. Slaughter.
I'm sorry, what you said, position 27?
37.
Oh, position 7?
37.
You said 37?
I'm sorry, it keeps going in and out. We can't really hear. What was the number?
It's 37, Judge.
37. Okay. I'm not used to there being 37 positions on this calendar. Please bear with me. All right. Good afternoon, Ms. Slaughter. Your case is 26 CR 00454. I'm sorry, 0000454E. You're charged with criminal trespass and damage, as well as simple battery family violence. Do you understand your rights today? Where is Ms. Slaughter? Is she at ACDC? Okay. You understand your rights? Yes. Okay. Mr. Howard?
4. Last arrest was on the 18th of this month. Suspended license. 2017 obstruction, first offender. Level 2.
Okay, thank you. Mr. Sirocco?
Yes, Your Honor, this was a September 26th incident from last year. It took place at 540 Cairo Street, Northwest in Atlanta. Officer made contact with the victim, Miss Victoria Slaughter. She explained the defendant, who is her daughter, had caused damage to her window, front door, and cell phone. The defendant had arrived at the location upset. This was following her being, and seems to be stemming from her being evicted from her residence, and was trying to move her belongings into the location of Miss Victoria Slaughter without her permission. She says you can't do that. It's currently under construction. And the Miss, excuse me, the defendant's child has been residing at the location with Miss Victoria since he was born, but the defendant is always on the go, trying to stay down and unable to care for the child. In this incident, she barged inside the residence, pushing past her near where the victim's mother was resting, and Miss Victoria tried to have her step outside of the location to talk on the phone and distance herself. Miss Tisha followed her outside, and while standing in front of the residence, the defendant took the victim's phone while she was on the line with the 911 dispatcher and threw it into the street, then proceeded to mush the victim in the head, and before going back inside of the location, Miss Victoria was able to contact law enforcement again. It was at that point that the defendant began taunting her from outside and began to kick the front door. causing one of the wooden panels, to break off. Also ripped off all the screens off of each of the front door windows, or the front windows, excuse me, and banging on the windows as well. Officer observed the damages to the property, and ultimately the defendant was arrested. We have spoken with Miss Victoria Slaughter. She confirmed the events in the warrant. She states the defendant has not been home since the incident and is currently staying at a shelter. She's taking care of the defendant's child. She stated that the defendant told her she will pay for the damages to the door and the phone when she is able to afford that. She's asking for stay away as well as no further violent contact. The state's recommendation is a signature bond through pretrial. We are recommending 2 days anger awareness as well as a social worker visit for housing and potentially BHET if necessary. No further violent contact with Victoria Slaughter. Stay away from 540 Cairo Street Northwest in Atlanta. And no drugs, weapons, or alcohol while out on bond. If we could sound for Miss Slaughter at this time.
All right, is Miss Victoria Slaughter on the line and wishes to make a statement? If so, please unmute and raise your right hand. I'm sounding again for Victoria Slaughter. Okay, seeing none. Miss Kim?
Yes, we have no objection to signature on bond through pretrial. For the record, she loves her son. I mean, that's it. Everything else,
Yes, I'm here.
Okay, hold 1 second. Go ahead, Miss Kim.
oh, that's it, Your Honor. We have no objection.
All right, Miss Slaughter, you need to unmute again and then turn your camera on, raise your right hand.
Okay, I'm trying. I'm not savvy.
All right, please, I see you now. Please raise your right hand.
Okay.
Do you swear or affirm that the testimony you give today will be the truth to the best of your knowledge?
Yes, ma'am.
All right, what would you like to tell us?
No more than what the he stated that she has not been back in the house since October, since September, since the accident, and over at the Atlanta Mission trying to get a place to stay through the program, trying to get a place, and just means she's gonna pay the door and all of that when she get her tax return um, soon for the door and my phone. Other than that, it's she hadn't been here since September. No more than
Do you
dropping.
have any concerns for your safety, and do you wish to have contact with her?
No more. No, what we've been doing so far since September, it's been going fine. She hadn't been here no more than she take chosen from the take him to school. I get him off the bus. Then when she picks him up to go back to the shelter, I let him out the door. That's it. That's all the contact we have.
Okay.
I will not contact, but just her in the program, taking chosen in school. He comes here when he get out of school, because that's what we was doing from the beginning before this happened. And then at 7 o'clock, when she go back into the shelter from work, she come by, I let him out the door, and that's it.
So it seems like you don't have, she does come by your house, is what you're saying.
Just as far as, because she don't have nobody to watch. She's in the shelter, Atlanta Mission Shelter, and that's their policy. So she drops him off at school because he was going to school from here and coming home from here before she had got evicted from her apartment. So at that moment, this is the only thing, once again, that I'm trying to help her as far as my grandson. So now she's up under a program at the mission and trying to get another place to stay, but not here in this house.
All right. Okay. So, before I rule, anything the state or defense would like to add in light of that statement? Very briefly.
No, Judge.
Okay. All right, defendant is going to receive a $3,000 signature bond at level 2 through pretrial services. It'll be 1,000 on count 1 and 2,000 on count 2. She's to have no further violent contact with the alleged victim. She's going to take the 1-day anger awareness course and have no alcohol, no drugs, no weapons. Is there anything additional?
Nothing further from the Honor.
All right, best of luck to all parties concerned. Ms. Slaughter's case is concluded for today. Who do we have next?
Number 2, Mr. Barber.
Mr. Barber, good afternoon. Your case is 26 CR 000442J. In this case, you're charged with battery family violence. Do you understand your rights today? All right, Mr. Howard.
2020, I'm sorry, 22 total. The PSA said it was a FTA from 2026, but it's actually 2025. 2017, possession of meth, possession by a convicted felon, possession of a firearm, actually. Conviction, 2017, probation. 2015, conspiracy to commit a felony conviction. Level 3.
Okay, thank you. Ms.
Excuse
Evans
me, what
Battle.
position is this?
Number 2, Mr. Jerry Barber.
Okay, thank you.
All right, Ms. Evans Battle.
Yes, Your Honor. In this particular case, it occurred September the 18th of 2025, when officers went to 7990 Bear Creek Trail in South Fulton. The victim in the case is Jessica Barber, and she indicated that her husband had assaulted her. That she came into the residence, and he was indicating that there was some confrontation about an affair. I believe he thought she was having an affair with someone. She went to leave the residence, and he blocked her in the driveway with a tractor that was parked in front of her car, so she couldn't get out. And as well as when she went to leave and get into another vehicle, it was also blocked. She saw that one of the vehicle's doors was open. She got in the door. He pulled her out of the door and began to punch her in the face. We are asking for that bond be in the amount of a surety bond in the amount of $5,000 at this particular time, that he have no contact with her, and that he stay away from the 7990 Bear Creek Trail location. No alcohol, drugs, or weapons while out on bond. Thank you, Your Honor.
All right, thank you. I'm going to sound for Ms. Barber if she wishes to make a statement. Hearing none, Ms. Cook.
Thank you, Your Honor. Mr. Barber is 44 years old. He's been in Georgia all his life. He's resided at that 7990 Bear Creek Trail address since he was 9 years old. That's his parents' home. It's my understanding that Mrs. Jessica Barber has not been at that address since November 3rd. They've been married for 18 years. They share a total of 3 children, a 19-year-old, 17-year-old, and a 3-year-old. It's my understanding that the middle son, the 17-year-old, still resides in Georgia with Mr. Barber. The 3-year-old is with Mrs. Barber, and they do co-parent. He is employed. It's my understanding he is employed. He does have his highest level of education is a associate's degree where he was studying automotive technology. He has good contact information, good family ties. We would be asking the court for a signature bond. It's my understanding that even though, I understand this happened back in September. I asked him how did he get picked up? It's my understanding that he previously was picked up in Pike County. They transferred him to Grady. He was released from Grady. He was picked up again for whatever reason, transferred to Grady and released from Grady. This time they took him straight to Wright Street, and that's why he's here before the court. I don't believe he picked up a new charge to get before us today. We are asking the court, he doesn't have an issue with no further contact so long as he can still have contact with his children. So maybe no violent contact with her. Again, she no longer resides at that residence, so we would be opposed to the stay away as that's his home, and she, is my understanding, no longer lives there. And I believe that was it. No issues with the no alcohol, drugs, or weapons. We will again be asking the court for a UJR on these.
Can anyone check and see how long he's been booked in on this charge before we do the Riverside issue? Let me look myself
Okay.
as well.
I have. Because I have, he was just booked on the 20th.
Mine is showing the same, Judge.
Okay, I don't think we have I don't see anything in here about the other stuff, Ms. Cook. I'm not hearing the Riverside.
To clarify, I wasn't making a Riverside. I was saying he was previously picked up in Pike County. They transferred him to Fulton to Grady, but they released him from Grady, never actually took him into Wright Street.
Oh, okay.
That happened again. So it happened several times. And so finally he's here before the court. So it's not as if he was running away, not trying to address this. I believe he has medical concerns, and that's why they always would take him to Grady first.
Okay, understood. Defendant's gonna receive a $2,000 surety bond. He's to have no contact with Miss Barber. They can use a third party to coordinate transfer of his children. I'm not gonna order stay away in light of the information that is his home. He needs to return one time with a member of law enforcement to make the determination that she no longer resides there. If she is still there, he must collect his items and stay away. If she has vacated the premises, he is free to return to that residence. He's to have no alcohol, no drugs or weapons, and because he's receiving a surety bond, he will be reset to all purpose on February 3rd. Is there anything additional from state or defense?
No, Your Honor.
No,
All right. Best of luck, sir. That concludes your case for today. All right, who do we have next?
Position number 35, Simpson.
All right, and this is Reza Simpson. Is that correct? Good afternoon. Your case is 26 CR 0004458. In this case, you're charged with battery, family violence, and simple battery, family violence. You understand your rights? All right, Mr. Howard.
First.
All right, thank you, Mrs. Sirocco.
Thank you, Your Honor. This incident took place December 2nd and this was 2025, at 721 Longleaf Drive, Northeast in Atlanta. The officer spoke with the victim, Jamon Hansu, who explained the defendant, who is his ex-girlfriend, was given a notice to vacate the premises. He does not want her there. He stated that Miss Simpson had been living there for about 3 to 4 years. The two shared children together, two of them. And after telling the defendant to leave, she became upset, stood by the door of his vehicle inside the garage. And he was actually trying to leave the location at that point. The defendant then began to strike his face with a closed fist. As a result, he sustained a red, swollen left eye. Officers later found the victim, and ultimately she was arrested on the warrant this month here. We have not spoken with Mr. Hansu yet. Out of an abundance of caution, we are recommending no further contact and stay away. In total, the state's recommendation is going to be a signature bond through pretrial services, 2 days anger awareness, no further contact with Jamon Hansu. Stay away from 721 Longleaf Drive, Northeast in Atlanta, and no drugs, weapons, or alcohol while out on bond. If we could sound for Mr. Hansu, excuse me.
All right, is Mr. Hunt still present, wishes to make a statement? All right, thank you. Ms. Kim?
Yes, Your Honor, that place, my client says that her child resides there, and I guess the owner is the business. It is owned by LLC, and the child's father currently is residing at United Kingdom. He travels a lot for work, so he wants to stay. She wants to stay in that location. She graduated from high school 2009. She went to Atlanta College for studying, and she is right now a licensed realtor, both in Florida and Georgia. This is her first arrest. We would like to request for no further violent contact. Thanks.
And Your Honor, I do have from the report at least that location is his address. Absent word from him, we are still going to be asking for no further contact and that stay away.
All right. Defendant is going to receive a $2,000 signature bond through pretrial services. It'll be $1,500 on count 1 and $500 on count 2. She's to have no contact with the alleged victim and stay away from that location. She's additionally to have no alcohol, no drugs, no weapons as a condition, and she's going to take the 1-day anchor awareness course. Is there anything additional from the state or from the defense?
No, Your Honor.
Verify that it is level 1.
At level 1, yes.
Miss Simpson, you have a right to remain silent. I understand that you have some questions. And please feel free to call me. Stay away. It's involved minor children that are there. So may we please have a one-time law enforcement officer visit to retrieve her personal belongings and her children?
Yes. You can have, we'll add the one-time law enforcement escort. All right. Best of luck to all parties concerned. Who do we have next?
Number 15, Mr. Graham.
All right, Mr. Graham, good afternoon. Your case is 26 CR 0004543J. In this case, you're charged with criminal trespass. You understand your rights?
Yes.
All right, Mr. Howard.
Pen. You got to open giving false name, 3 counts. You got to open shoplifting. 2025 fade to appear. 2022 fade to appear. And he got a bench warrant out of state court.
Okay. Thank you. Ms. Evans Battle.
Yes, this incident occurred January the 20th of 2026 when he went to the Food Mart gas station located at 3749 Campbellton Road Southwest. He had already received notice not to be on the property, and the owner, staff member saw him there and reported to law enforcement. There's a bond set in the amount of $1,200. We just asked that it remain the same. It's a surety bond, and stay away from the location at the Food Mart on Campbellton Road. Thank you, Your Honor.
Thank you. Is this your client, Ms. Cook, or is it Ms. Kim?
Oh, it's mine, Your Honor. I'm sorry, I didn't hear you. Mr. Graham is 45 years old. He has been in Georgia all his life. It's my understanding he has been employed 10 years at a mobile detailing company. He's a high school grad. Even though he works, he does still qualify for public defender services. So his income is limited. Your Honor, as it relates to the open case 25 CR 002574J with that's the 2025 FTA. When I looked that case up in Odyssey, it looks like he never actually received notice. It was returned back to sender, but in Odyssey, his address, they had 2 different addresses. So it went to a different address, not his current address. But his current address is in Odyssey. So it would be my argument that he he is someone who would come to court as long as he receives notices to come to court. I do have good contact information for him based on his limited income and the nature of the charge. It's a criminal trespass. We will be asking the court for signature bond, or if not a signature bond, a very low surety bond. And if we could, I don't know if you have the authority to, but I see that he has a $2,000 surety bond on the FTA, but he never received notice. I don't know if that's something you're willing or able to address.
I don't think I can address the FTA today, but on this particular case, defendant will receive $1,000 surety bond. He stay away from that location and have no alcohol, no drugs, or weapons. Is there anything additional?
No, Your Honor, thank you.
All right, sir. Best of luck to you. That concludes this case for today. Who do we have next?
Question number 4, Ms. Berry.
All right, good afternoon, Ms. Berry. Your case is 26 CR 000-421C. You're charged with battery family violence and simple battery family violence. You understand your rights? All right, I'm assuming that is a yes. Mr. Howard?
First. Lower.
Thank you. Mr. Sirocco?
Thank you, Your Honor. This incident took place January 19th of this year at 945 Brandon Ridge Drive in Roswell. Law enforcement responded to a welfare check called in by the victim, Blake Dickey's ex-wife, Amy Dickey, regarding the safety of the residents there. She shares a son with Mr. Dickey. Officer spoke with Mr. Dickey, who explained that the defendant, who is his fiance and has lived with him at the residence for 2 years, got into a fight with him while they were intoxicated early that morning. Officer observed visible teeth marks on his left thumb area where the victim reported that the defendant had bitten him. Defendant, when contacted, ultimately claimed that she attempted to leave the house and that Mr. Dickey would not allow her to, that he wouldn't move out of his path and for that reason bit his thumb. We did speak with Mr. Dickey. He stated this was an isolated incident and that his ex-wife did not hear any altercations, but it was a mutual friend that told her about the incident. And that's when she called in to the police for a welfare check. He said the defendant may have gotten a little too drunk, but he never felt at risk or in danger. He also said the cut to his thumb is a minor surface level cut. And when asked if anything like this had ever happened before, he stated that police were called several months ago for another incident, but no arrests were made there. He is asking for no further violent contact and states that a stay away is not needed. I will state, however, we did listen in on the jail calls here. The victim had said to the defendant over the calls that officers told him he needed stitches and also had, it sounds like, bruising on his eyes. Questioned why the defendant did not say what he told her to say and told her to take the incident as a warning to stop being violent. With that and the reference to that prior incident where police were called, that suggests this is part of an ongoing violent problem here, and that gives the state cause for concern. So we are going to be asking for no further contact and a stay away. But in total, the state's recommendation is a $1,500 total surety, $1,000 on the battery family violence, $500 on the simple battery family violence. We are, as with what I've stated, recommending FFIB as well as no further contact with Blake Dickey. Stay away from 945 Brandon Ridge Drive in Roswell, and no drugs, weapons, or alcohol while out on bond. I do see him on the line if we could sound for Mr. Dickey.
Mayor.
Hold on. All right, Ms. Dickey, raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, I do.
All right, what would you like to tell me?
Some of the facts that were presented are not what I said to the police, and so I told them I did not think anything was violent, and I told them that I did not request any no contact at all, and definitely no stay away.
Okay. Is there anything else you'd like me to consider?
Yeah, well, I think that my ex-wife calling was hearsay from a mutual friend. So.
Go ahead. Most concerned about concerns for your safety and whether you wish to have contact with the defendant.
I'm not concerned about my safety, and I do wish to have contact with the defendant.
Okay. All right. Ms. Cook, is this your client?
Yes, Your Honor.
Please proceed.
Miss Berry is 25 years old, no criminal convictions. She does reside at the address with the incident location with her boyfriend, Mr. Dickey. She's been in Georgia all of her life. She's been employed at local tavern for about 2.5 years, where the restaurant is in Roswell, where she serves as a bartender. She completed some college, 3 years actually, at Kennesaw State University, where she was studying economics. She doesn't have any children. And I do just want to reiterate that neither she nor the alleged victim are the ones who called the police. This was more of an ex-wife who heard through the grapevine that something happened and did a welfare check. We heard from the victim that he does want to have contact, so we would ask the court for no further violent or harassing contact with Mr. Blake Dickey. At this particular time, we think it's premature to order a FFIB, as there has not been a history of arrest. This is her first arrest, and he's not afraid for his safety. If anything, we would ask for the 1-day anger awareness course. We would be asking the court for a signature bond on these charges. She doesn't have a criminal history. She's not a flight risk. She's been in Georgia all her life. The victim is not concerned with his safety. So for those reasons, we would be asking for a signature bond on all charges. Thank you.
All right, defendant is going to receive a $4,000 signature bond through pretrial services at level 1, $3,000 on count 1, and $1,000 on count 2. She's to have no further violent contact with the alleged victim and take the 2-day anger awareness course. Have no alcohol, no drugs, no weapons, and will be reset for the notice. Is there anything additional?
No, Your Honor.
No, Your Honor.
All right.
Thank you.
All right, best of luck to all parties concerned. Who do we have next?
22, Mr. James.
All right, good afternoon, Ms. James. I'm sorry, Mr. James. You said 22?
Ma'am.
Okay, I'm sorry. I thought we were going to ACDC. All right, your case is 26 CR 000452D. In this case, Mr. James, you're charged with battery family violence. You understand your rights?
Yes, ma'am.
All right, thank you, Mr. Howard.
First.
Thank you. Ms. Evans-Battle.
Yes, Your Honor, I think he said first, but I think there's another incident. But I think that we were just made aware of, I think he has a superior court case as well. In this case, it took place August the 27th of 2025. Officer John Baptiste went to 5485 St. Lou Lane in South Fulton, spoke with the victim in the case, Janiyah Terry, and she indicated that she and a coworker got into an argument and they had to leave the job early. And so she went home and went to the location of that coworker and damaged that person's property, keyed his car. Or I don't know if that's a girl or a young lady or male. She came home and told Mr. James and Mr. Thomas had in fact called Mr. James and told him what had taken place. There was a physical altercation between Mr. James and the victim, Miss Terry. He punched her in the face, in the head. he left the location, and when he left the location, he took a credit card. There were visible lacerations to her neck, to a finger, there was bruising on her face, in her upper forehead, that the officer was able to observe. She indicated to him that more than likely Mr. Thomas was at his mother's home, so he was not on location and was not arrested at that particular time. Our bond recommendation is for a $5,000 surety bond, no further contact, stay away from the location, third-party contact with the children. I believe there is a pending PI case, and my understanding that bond was denied when I looked today at that case. Let me pull it up. Mr. Howard, don't see it.
See what?
For Mr. Javante James, a new case, a PI case.
He probably went to court for it earlier. I'm not sure.
Yes, you're right. He went to court for that earlier today. And the bond, there was a motion for a bond and it was denied.
So he got no bond for that?
He got no bond for it.
Okay.
Thank you.
All right, thank you. Ms. Terry, please unmute if you wish to make a statement and raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right, what would you like to tell me?
I just want to say that I don't know if you want me to speak on the first incident, like when he just got out of court for that one, but this one with the Thomas situation and my eye being black, I never communicated with my doctors or the police that Javante did anything to me, because he didn't. I didn't even see him that day. He knew about it when I got to the hospital, and I called him and I let him know what happened, but he didn't harm me. He didn't assault me that day. And I talked to somebody earlier on the phone, and I had let them know that I did want him to make bond, and I'm not threatened by him. I don't feel that he's a threat by me. I just want him home with our children. We got a 1-year-old and one on the way. So that's all I got to say right now.
All right. All right, I appreciate you coming to court to make that statement. Who represents?
And Judge, as to that 26 DA 00625, there's a no further contact in that bond.
Yeah, I was assuming. So if it went to felony, there's always a no contact. Who represents it? Ms. Kim, please proceed. And my question is, I know you're going to advocate for the signature bond, but in light of the fact that your client got no bond on the other charge, you would still request a signature bond, even if he wouldn't accrue any time on this charge?
May I please discuss that with my client for 1 minute?
And I'm again, you may, but I'm not even saying I'm inclined to. I just wanted you to put that perspective out there, but go ahead.
Sure. Yeah, he is willing to take surety bond, Your Honor. I believe that alleged victim, Miss Terry, and my client, they do not live together. They are still dating, and they have 2 children together. 1 years old, and the other one is still on the way. Your Honor, my client completed GED, and he is working to get licensed for a CDL. He's only 20 years young. I referred him to take classes at LADDER, LADDER, so we can hopefully negotiate pretrial diversion with our solicitor's office. He does not have a job at this point. He cannot pay for the bond, and even though he can pay for the bond, there's no bond for his PI case, so he will be here regardless. We would like to request for no further violent contact and signature bond pre-trial. 11-1, if possible. Thank you.
All right, defendant is going to receive a $2,000 surety bond. He's to have no further contact with the alleged victim consistent with the felony order. He's to stay away from that location and have no alcohol, no drugs, no weapons. Is there anything additional from the state or from the defense?
Your Honor, that location is actually my client's place, and she has a different address. The
Okay.
incident is hers. Oh yeah, never mind. I got confused. The incident location, he has no objection to stay away.
Okay. All right. Is there anything additional from the state of the defense?
Nothing further from the
No,
defense.
Your Honor.
All right. Best of luck to all parties concerned. That case is concluded for today. Who do we have next?
Question number 21, Ms. Holland.
All right, Ms. Hollins, your case is 26 CR 000-409H. In this case, you are charged with obstruction and disorderly conduct. You understand your rights today? All right, Mr. Howard.
Third, she got 2 DUIs from 2024. Level 2.
Okay. Ms. Evans, battle.
Yes, Your Honor. As to Ms. Hollins. Cases are running together. Yes, this incident occurred January the 19th of 2026. Officer went to 3480 Camp Creek Parkway in East Point, which is the Longhorn Steakhouse, in reference to a disorderly person. They met with the manager there, who indicated that they, in fact, had previous problems with the defendant. She was pointed out by the staff, and she was leaving the location, and apparently she was, in their mind, she was leaving the location and she hadn't paid the bill as well. They indicated that because of her abusive and vulgar language, they wanted her criminal trespass, and her behavior escalated even in front of the officer, and she threw a receipt at the officer, refusing to follow lawful commands. They had to tussle with her in order for her to be cuffed and arrested. The recommendation is for a $5,000 surety bond signature bond through pretrial services level 1. We would ask that she complete an ADET as well, and no alcohol, drugs, or weapons while out on bond. Thank you.
Okay. Ms. Cook?
Yes, Your Honor. Ms. Hollins is 26 years old. We're not opposed to the signature on bond. The only condition we would object to would be the ADET. I do understand this is her third arrest. He mentioned 2 DUIs prior. I believe 1 was dismissed and 1 is still pending that she's actively fighting. It's my understanding she has no issues with not going back to the Longhorn Steakhouse. She doesn't really know Ms. Hawthorne, so no issues with the no further contact, no issues with no further violations of the law, or no drugs, alcohol, or weapons while on bond. She is a high school grad, currently unemployed, been in Georgia since 2020.
All right, defendant is going to receive a $10 cash bond, $5 on each count. She's to stay away from that Longhorn and have no alcohol, no drugs, no weapons. Is there anything additional? Best of luck to all parties concerned. Who do we have next?
29, Mr. Henderson. Sorry, Matthew,
I'm sorry, the 29 Patterson, is that where we're going now?
Yes, ma'am.
All right.
Go ahead, go ahead.
All right, good afternoon. Your case is 26 CR 0004441F. You're charged with theft by shoplifting and criminal trespass. You understand your rights?
No, I didn't know about criminal trespass.
Is that a yes?
Well,
You don't understand your rights? You have a right to remain silent, and you have a right to an attorney. You understand that? All right, Mr. Howard.
51. The booking said resident of South Carolina. We got open shoplifting out of Chambly. Two more open shopliftings out of the cab. I got two FTAs from 2025. 2025 shoplifting obstruction conviction. 23 shoplifting conviction. 23 failed to appear. This is at level 4.
All right, thank you, Mr. Sirocco.
Thank you, Your Honor. And I also have FTAs from 2025, two of them, and an older FTA from 2016. Additionally, I see that he appears to be wanted out of Somerville, South Carolina for failure to appear. Um, Obviously, flight risk there with his residency, and with that, um, the incident here took place January 19th. This was at the 844 Cleveland Avenue Walmart in East Point. Asset protection alerted officers to an individual later identified as a defendant observed shoplifting throughout the store. He was found in possession of roughly $81 worth of merchandise in his pockets, and he had previously been caught shoplifting and given a criminal trespass warning on November 20th, 2025. Placed under arrest. The state's recommendation is that bond, with his history, FTAs, and the flight risk here, is that the bond remains set. Currently, it's 1,560 total surety bond. It's split between each charge 780 apiece. Stay away from the Walmart at 844 Cleveland Avenue in East Point. No drugs, weapons, or alcohol while out on bond. And that is all for the state on this case.
Thank you, Ms. Kim.
Yes, Your Honor. I am actually going to ask social worker to have an interview with him for housing resources and also PHUT. We have no objection to 1560 surety bond.
Okay. I'm sorry, you have no objection to. I lost you for a moment, Ms. Kim. What did you say at the end?
We have no objection to current recommendation of the remaining set.
Okay.
$15.60.
Okay, bond will remain as set as the 780 on each count. And he is to stay away from that Walmart on Cleveland Avenue, have no alcohol, no drugs, no weapons, and I'm gonna ask for the social worker visit with him. He will be reset to state all purpose on the 3rd. Does that conclude our business today? I'm sorry. Anything additional from the state of the defense?
Nothing from the state, Judge. Thank you.
All right. Best of luck to you, sir. That concludes your case from today. Hearing none from Ms. Kim. Who do we have next?
Number 36, Ms. Napoli.
Ms. Annapolis, your case is 26 CR 0004378. You're charged with battery family violence in this case. Do you understand your rights? All right, Mr. Howard.
What number is this?
36.
Third arrest, 2019 shoplifting, 2018 trespass. He got a fugitive warrant out of Alabama. So, yeah.
Okay.
I think it's for property crimes, what the warrant said.
All right, Ms. Evans Battle.
Yes, Your Honor. On January 16th, the officers went to 396 Brownlee Road, Southwest, to an apartment. The victim is Lanarian Hinton, Lanarian Hinton. Her first name is spelled L-I''Nearaen. She indicated that her sister came to the home and was beating on the door to get in. Once in the home, she threw water on her and started an argument that quickly turned into a physical when Miss Alexis struck her multiple times in the face with a closed fist, causing bruising and swelling to her face. If she is eligible with that warrant, state's recommendation is for a $3,500 signature bond through pretrial services level 2. No further contact with Ms. Hinton, and stay away from the 396 Brownlee Road Southwest address. That would be our recommendation at this time.
Is Ms. Hinton present and wishes to make a statement? Okay, hearing none. Ms. Kim?
Yes, Your Honor, I believe she was booked on January 17, 2026, which is Saturday, Sunday, Monday, Tuesday, and Wednesday, 5 days. I believe this is a Riverside issue, so we would like to request for a signature on bond through jail and look for notice for next court date.
All right, go ahead.
Yeah, she's only 25 years old and she graduated from high school 2020, currently working as a hairstylist. She has a 2-year-old daughter. This is her first arrest. But since it's a Riverside issue, we would like to request for a signature on bond through jail.
All right, defendant is going to receive a $2,500 signature bond through pretrial services at level 1. She's to have no further violent contact with the alleged victim. Is there anything additional?
Nothing for the front bench, Your Honor.
All right, best of luck to you, ma'am. That concludes your case for today. Who do we have next?
34, Mr. Sanchez Figueroa.
All right, Mr. Sanchez Figueroa, your case is 26 CR 0000444Y. You're charged with battery family violence and simple battery family violence. Do you understand your rights today?
Yes, Your Honor.
Thank you. Mr. Howard?
First.
All right, thank you. Mr. Sirocco?
Thank you, Judge. This was a December 25th, 2025 incident. Took place at 2258 Headland Terrace in East Point. Officer responded to the location and made contact with the victim, Mr. Luis Figueroa, who was at the time on top of his nephew, the defendant, to restrain him from fighting. There was an altercation wherein the defendant struck the victim in the face with a closed fist, causing him to bleed from his, causing a laceration to his left cheek there that was bleeding. The victim was trying to calm down another altercation that was going on between the defendant and his father. They live there at the location together. Defendant openly admitted to punching the victim in the face, stating, quote, "I popped him," and was ultimately arrested. We have spoken with Mr. Figueroa. He stated the defendant's been doing much better and has gotten himself together. The victim is the nephew of the defendant or is the defendant's nephew, excuse me. Yeah, excuse me. The defendant is the victim's nephew. He has helped raise the defendant since he was 2 months old. He's okay with no further violent contact and states that a stay away is not needed. He plans to move out soon. In any case, he doesn't own the home. It was a gift to the defendant's mother. He's okay with the defendant returning home. The state's recommendation here is a signature bond through pretrial services. We are recommending 2 days anger awareness, no further violent contact with Luis Figueroa, and no drugs, weapons, or alcohol while out on bond. I believe I saw him on the line. If we could sound for
Yeah,
Mr.
he's
Figueroa.
present. Before we do that, this was first arrest, I'm confirming. Everybody did say this was first.
We didn't find a record, Judge, so best we can do is assume that it is first.
Okay. All right, sir, if you wish to make a statement, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes.
All right, what would you like to tell me?
Just want to say that Salvador is doing a lot better. It was a one-time incident. Not aware of any criminal record from him, so he's more than welcome to come home. We are expecting him.
All right, thank you. I appreciate you coming to court to make that statement. Um, Ms. Kim, please proceed.
Yes, we have no objection to signature on bond through pretrial level 1, Your Honor. No further violent contact. My client does not have any objection.
All right. Defendant is going to receive the $3,000 signature bond through pretrial services at level 1, $2,000 on count 1, and $1,000 on count 2. He's going to take the 2-day anger awareness course, and he's to have no further violent contact with the alleged victim. He's to have no alcohol, no drugs, no weapons. Is there anything additional?
Nothing further from defense, Your Honor.
No, Your Honor.
All right. Best of luck to you, sir. That concludes your case for today. Who do we have next? I'm sorry, I couldn't hear.
Mission 24, Ms. Mallard.
24. Oh, Mr. Mallard.
Miss
Miss Mallard. My apologies. All right. Good afternoon. Your case is 26 CR 000-421F. In this case, you're charged with simple battery. Do you understand your rights? All right, Mr. Howard.
Third, 2022, disorderly conduct, giving false name. That was dismissed. 2020, shoplifting conviction, level 1.
Okay. All right. Thank you, Ms. Evans Battle.
Yes, this happened December the 15th of 2025 at 44 Bay Street in Fairburn. The victim in the case is Austin Heyman, who is an Uber driver, and Miss Mallard became upset because he would not take her to the QT for free. And the victim had a video footage of the incident, and she spat on him as a result of his refusal to her request. The bond recommendation is $2,500 signature bond through pretrial services level 1. No further contact with Austin Heyman. No alcohol, drugs, or weapons while out on bond. That she completes. We are asking for 3 anger awareness classes. Nothing further, Your Honor.
All right. Is Austin Heyman present and wishes to make a statement? All right. Ms. Kim?
Ms. Mallard, you have the right to remain silent. You've got the signature on bond, so please.
We don't know that she has that though, but go ahead, Ms. Kim.
Oh, she will. We have no objection to state signature on bond through pretrial, Your Honor.
Why don't you tell me about your client?
She is 24 years young. She was born and raised here in Georgia, Your Honor, and her mother is here to support her. She has all her family members here. The incident location, 44 Bay, is actually her own place. And of course, Uber driver and my client have no residence together at all. They don't share. Actually, there was a consent bond offered by the ASG Mary Evans Battle, and then we wanted to take it. So that's it, Your Honor.
All right. Defendant is going to receive a $5,000 signature bond through pretrial services at level 2. She's going to take the 3-day anger awareness course. She's to have no contact with the alleged victim, and she's to have no alcohol, drugs, or weapons. Is there anything additional?
Nothing further from the.
Ma'am, do you have a brief question about the bond? Please don't say anything to incriminate yourself. The state is listening. What's your question?
No, I don't have a question, but what she said is like I paid for.
No, don't do that. Don't do that. The state is listening, and you may think you're helping yourself, but more than likely you're not. Okay. Best of luck to you. Got a signature bond. You can fight this another day. All right. Who do we have next?
Number 14, Mr. Ito.
I'm sorry. Say that again.
14, Mr. Ito.
Thank you. I'm sorry. It's just hard to hear. I'm trying to move us as quickly as we can. Mr. Ito, your case is 26 CR 000-430B. You're charged with criminal trespass and damage to property. You understand your rights?
Yes, ma'am.
All right, thank you, Mr. Howard.
First,
All right. Thank you, Mr. Sirocco.
Thank you, Judge. This incident took place August 22nd, 2025. This was at 19206 Deer Point Court in Alpharetta. Officers responded to a DV call and made contact with the victim. Upon arrival, Miss Leslie Taylor. She explained that the defendant, who is her son, had gotten into a verbal argument the night before that continued into the next day, that officers responded. She was trying to parent him about going out late and hanging with friends, and he got upset and belligerent, and while yelling and walking around the location, kicked the wall, her wall in the home, causing a large hole in said wall. Also flipped over couches, but nothing there was damaged. Officer did observe the hole to the drywall. We did speak with Miss Taylor. She did not, she never intended for an arrest to be made here. There are several concerns that she goes into with respect to MH that I will not go into, but he is receiving treatment for that following an incident roughly a month ago. He's been much better since he's been out on treatment, and that is all for the state on that. The state is recommending a signature bond through pretrial, that the defendant continue with any prescribed medication and or treatment, have no further violent contact with Leslie Taylor, and no drugs, weapons, or alcohol while out on bond. Um, and we would ask that the court sound for Ms. Taylor, but I want to make sure we don't go into any MH issue. If Your Honor could caution her about that.
Okay. I'm concerned. Ms. Taylor, if you're present, um, please don't make any reference to any medical or health issues. But if you'd like to make a statement, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes.
All right. What would you like to tell me? Again, with those same instructions in mind.
Okay, so there should be no criminal trespassing charges at all. So I called for the EMS. I didn't ask the police to press any charges. So I called to get the EMS there for medical treatment, but nothing as far as trespassing. And when it came out on August, I did not say that he put a hole in the wall. So I don't know where to get that information from, but they came out again another time when there was another incident that happened when he banged his head into the stove and shattered the glass on the stove. So I called to get him some help. Yeah.
Okay. All right. Thank you, Ms. Taylor. I appreciate you coming to court to make that statement.
And like, can these charges be dropped? Because this is like a waste of time. And he lives here too. So I don't know how you can possibly trespass in a house that you live in.
Well, I appreciate your perspective on that, but this is a bond hearing. We're only setting bond today, okay?
Okay.
And the definition of trespass is a little bit different than you might think if you look into it a little different. But I do appreciate you coming to court to make the statement.
Okay.
All right, Ms. Cook.
Yes, Your Honor. And I'm sorry if I mispronounced his last name. Mr. Oda is 19 years old. He's been in Georgia all his life. This is his first arrest, doesn't have any criminal history. It's my understanding he's been employed at Publix for the last year and a half. He graduated high school May of 2025. He tells me that he's intending to start at Gwinnett Tech in August of 2026. We are asking the court for a UJR on these charges. We've heard from his mother, who said that she never intended for this to be prosecuted. He has no issues with no further violent contact, no alcohol, drugs, or weapons while out on bar.
All right. Defendant is going to receive a $2,000 signature bond through pretrial services at level 1. He's to have no further violent contact with the alleged victim in this case, have no alcohol, no drugs, no weapons. Is there anything additional from the state or from the defense?
None, Your Honor.
Okay, Your Honor, thank you.
All right, this case is concluded for today. Best of luck to you, sir, and to all parties concerned. Who do we have next?
Position number 39 as well.
All right, good afternoon. Your case is 26 BR 0004447A. In this case, you're charged with simple battery, family violence. You understand your rights? All right, Mr. Howard.
First, this was on the MH list.
Okay.
Your Honor, could I get the position number for this? I want to make sure.
39. Well, Mr. Howard, when you say that list, what do you mean?
So
I'm
we
sorry.
we get a list emailed every morning
Okay.
from the jail, and she was on a
Okay.
is this a he or she? She was on it,
Okay.
but it'll just be assigned to one of our people in supervision.
Oh,
If you order the signature bar,
it gets different. It takes a different track.
it just be a inmate officer. That's all.
Okay.
We got a few of those downstairs.
Understood. Okay, thank you. I just want to be clear. Mr. Sirocco?
Thank you, Judge. So this incident took place January 20th. So yesterday at 2900 Landrum Drive, Southwest in Atlanta. That is an apartment complex. The officers made contact with the caller and the victim here, Mr. Vixen Robinson. He was escorted out of the house to speak with officers and explained that the defendant and the victim here have been dating for over a year, living together for the past several months, I believe since September. Um, Mr. Robinson explained they had been arguing that morning about food, and that the defendant became upset over the food situation and began attacking him. Stated that every room he would go into, she would come in behind, yelling at him and try to prevent him from leaving that room. He did grab her arm at one point to stop her from hitting him and pushed her out of the way so he could leave the room. He locked himself in the bathroom at one point and told her multiple times to stop, but she continued to try to break down the door, which ultimately led him to calling 911. There were marks on the door. There was broken glass on the carpet that officers observed. Excuse me. And when they spoke with the defendant, she stated that once he got in there being the bathroom, she kept wanting to check on him, but he did not answer. She said she threw her phone first, and then after that, a toothbrush holder, stating she just wanted to make sure he was okay. She pushed him at one point during the altercation here. We have spoken with Mr. Robinson. I confirmed the events in the warrant. He said there have been previous times where where she becomes irate, yelling, but it's never gotten to this point before. He states he's okay with no further violent contact and with the defendant returning home. She doesn't have anywhere else to go at this time. He does state that when the defendant does get in a mode such as this, he's unable to calm her down. They are in a relationship and they do not share any children. State's recommendation here in I see no history as a signature bond through pretrial services. We are recommending, given the victim's account and the facts here, 2 days anger awareness, no further violent contact with Mr. Robinson. Stay away from 2900 Landrum Drive, Southwest in Atlanta, that apartment complex, Your Honor, and no drugs, weapons, or alcohol while out on bond. If we could sound for Mr. Robinson.
Is Mr. Robinson present? Wishes to make a brief statement?
Uh,
Mr. Robinson, please you raise your right hand again. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, Your Honor.
All right, what would you like to tell me?
I would basically like to say that given her pre-diagnosis of borderline
No,
personality
no, no, no,
disorder.
no, 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 no. Don't do that. Please don't mention any mental or physical or any other sensitive information. This is a live recorded proceeding, okay?
Yes,
So
ma'am.
you
But
can go forward, but just
I
don't
would
do
say
that.
I would say that I would like to see maybe a evaluation or continued treatment if if I may able to request that. That's all I gotta say.
Okay. Understood. Thank you. And I don't mean to be harsh, but we do have to protect certain concerns,
I,
okay?
I totally understand.
All right, thank you. Ms. Kim?
Yes, my client is 24 years young, and Your Honor, after graduating from high school 2019, she went to go study at college for psychology. Right now, she is preparing to go to graduate school. And she also works at Walmart full time. She's a very hard worker, smart, and Your Honor, though for the violent contact, she has no other place to go, and stay away should be removed. We don't have any objection to the signature on bond through pretrial. However, we want to make sure she can return home.
And I think I may have misstated earlier. The state's not asking for a stay away, given the victim's request here. I absolutely that was before we had contact with them. So
Okay, awesome.
All right, defendant is going to receive a $2,000 signature bond at level 1 through pretrial services. I am going to ask, if possible, for a social worker to speak with her prior to her release to see if anything is necessary, but I'm not going to ask that the jail hold her if a social worker cannot make it before she can sign out. She's to have no further violent contact with the alleged victim in this case and have no alcohol, no drugs, weapons. This case will be reset for the notice. And Ms. Bridgewater, please note on the order that this needs to be assigned to an MH pretrial officer. Is there anything additional from State of Defense?
nothing from the state, Judge.
Nothing
All
else.
right. All right. Best of luck to all parties concerned on this case. Ms. Webb, that concludes your case for today. Best of luck to you. Who do we have next?
Excuse me, is it possible I can say something on the defendant behalf? I'm the mother of the defendant.
No, none at this time. Can we
Okay.
ask if there's a victim witness advocate or someone on the line who can speak with her and give her information? This is just a bond hearing today, ma'am.
Okay.
So really the other issues will be addressed at a later date. I am allowing the
Okay.
defendant to sign her own bond, okay?
Okay, thank you.
All right, best of luck to you. All right, who do we have next?
19, Mr. Henderson.
All right, Mr. Henderson, good afternoon. Your case is 26 CR 000-408E. You're charged with unlawful conduct during a 911 call. Do you have, you understand your rights today?
Yes, ma'am.
All right, Mr. Howard.
37, 2022 simple battery DV conviction. 2022 battery DV conviction. 2015 cruelty in the second conviction. This was level 3.
Okay. All right, Ms. Evans Battle.
Yes, between the periods of January 16th and 17th, Mr. Henderson called 911 operations over 7 times. Within the last 90 days, he's called them 98 times. Officers came to the home, and it's located at 5250 Jonesboro Road in Union City. And they indicated to him, they asked, of course, what's the emergency? Why are you calling? They've previously gone to the home for emergency services, finding that there were none that were needed. He reported to them on this day his wife and daughter were closing doors, and he wanted the police to know that he was also out of the hospital. Again, the officers indicated that it's a misuse of 911 calls. They have previously told him that if he did it again, they'd have to take him into custody, in which they did. We're asking for a bond in the amount of $5,000 surety bond. We are asking at some point if he is able to make bond or the court grants a signature bond that he meets with the social worker for mental health, and that he not communicate with 911. I'm not sure how we can manage that unless it is an absolute emergency and there's no one else present in order to make the emergency call on his behalf. No alcohol, drugs, or weapons while out on bond. Thank you, Judge.
Okay. Not sure how we handle that last request, but okay, Ms. Cook.
Yes, Your Honor. So Mr. Henderson is 45 years old. He's been in Georgia all of his life. He works odd jobs. It's my understanding he was recently in a car accident earlier this month and is undergoing treatment for that. He's obtained his GED. It's my understanding he is married, does have a 15-year-old daughter. I am just checking because I believe, okay, so never mind. It looks like he was given a $10,000 shorty bond before this. We will be asking the court for, his income is limited. And I do understand that he has a significant criminal history, 37 cycles, but what I didn't hear was any failure to appear. So it does seem like he has a tendency to at least show up for court. So we will be asking the court for a signature bond on these charges.
Okay. I'm still contemplating the special conditions. Okay, defendant is going to receive a $1,500 surety bond. He is to not call 911 unless it is an absolute and real emergency. He's to have no alcohol, drugs, or weapons, and he will be reset to state all purpose on February 3rd. Is there anything additional? All right. Best of luck to all parties concerned. I am going to ask for a social worker visit as well. All right. Who do we have next?
26, Mr. Mofford.
All right, Mr. Mumford, good afternoon. Your case is 26 CR 0004881. I'm sorry, 418Y. You're charged with simple battery and criminal trespass and damage. Do you understand your rights?
Good evening, Your Honor. Yes, ma'am, I do.
All right, thank you. Mr. Howard?
It's his third. He got an open suspended license, child safety restraint, and another suspended license. This is out of Tennessee. But level 2. That's
All
all.
right, thank you. Okay. Ms. Evans Battle?
Yes, this happened January 19th of 2026. Officers went to 138 Richmond Street Southeast regarding a dispute between he and Latrice Glover, who's the victim in this case. It appeared that when they were arguing because he had been out all night, and he started he indicated when the officer was speaking to him that there was no physical dispute that was going on, but there was a witness in the home who indicated that he in fact had hit Miss Glover, that she indicated she had entered the bedroom and turned on a light, and he became upset because there were children in the bed and they were not sleeping, or that they were sleeping on an air mattress. They were sleeping in the bed as well. And he snatched the blanket off of the bed. There was one of the children was actually wrapped up in the blanket. She said she got up with a younger child, and he came downstairs. He was angry and upset. He picked her up her phone. He threw it on the ground, causing the screen to break. He pushed her to the ground as well. The officers did not observe any visible injuries to her. The bond recommendation is for $1,500 on the criminal trespass and damage to property, and $2,500 on the simple battery, which would make a $4,000 signature bond for pretrial services at level 1. We are asking for 3 anger awareness classes, that he have no further contact with Ms. Glover, and that he stay away from the location at 138 Richmond Street Southeast. If she is present still at that location, that he be allowed a one-time visit with a police escort to retrieve his property. No alcohol, drugs, or weapons while out on bond. Thank you.
And I'm sorry, it was Latrice Glover. Is Miss Glover present? Wishes to make a statement?
Miss Glover isn't, Your Honor. However, the owner of 138 Richmond is, if I may
Oh,
speak.
no, we're only Miss Glover, the alleged victim in this case. Is Miss Glover present? Okay, hearing none. And I do appreciate it, but it's just a bond hearing today. Miss Kim, please proceed.
Yes, Your Honor. My client is 23 years young, Your Honor. That location, incident location, is actually his mother's place. And Your Honor, Miss Glover has moved out to be back to Memphis, Tennessee. So we would like to request that law enforcement officer to verify that she is not there. And once he verifies, I want my client to be able to go home. He has a full custody of one of the children, and with his mother, the owner of the house, and they all live there together. And that's something that we would like to request. No objection to stay away, nor for the contact with her. I mean, not to stay away, no further contact. No contact.
All right. So defendant will receive a $3,000 signature bond at level 2 through pretrial services. It'll be 1,000 on count 1 and 2,000 on count 2. He's to have no further violent contact with the alleged victim. Actually, no further contact with the alleged victim. And what we'll do is we'll do the law enforcement determination regarding the address. If she's gone, he does not have to stay away. And he's to have no alcohol, drugs, or weapon, and he's going to do a 1-day anger awareness course. Is there anything additional from the defense?
Nothing from defense, Your Honor.
All right. Best of luck to you, Mr. Mumford. That concludes your case for today. Who do we have next?
30, Mr. Price.
I'm sorry, what number?
Your Honor, the consent bond offer from ASG was denied, and also he refused public defender's representation. So this will be pro se, Your Honor.
I'm sorry, what number is he at? That part was cutting out.
30.
And sir, I strongly recommend that you take the services of the public defender's office. You wish to represent yourself today? All right, your case, Mr. Price, is 26 CR 0000436Y. You're charged with simple battery against a person who was either 65 years or older or who was pregnant at the time of the offense. You understand your rights today? Is that a yes? I need you to speak loudly since you're representing yourself.
Yes.
All right, thank you. Mr. Howard?
Third, 2012 obstruction, 2009 DUI conviction. Level 1. That's all.
All right. Ms. Evans Battle?
Yes, on January the 19th of 2026, officers went to 5,000 Agate, Agate Drive in Johns Creek regarding a dispute. Patrice Price, I believe, is the mother. She indicated there was a dispute between her son, Mr. Christopher Price, indicating that he was not being compliant with medication. She indicated that he started yelling at her, and the father, Charles Price, who's the victim in this case, confronted him about the argument. And Mr. Christopher Price got into Charles's face and pushed him. They struggled. He pushed him so hard during the struggle that the officer was able to see marks against the wall where Mr. Charles' head had hit the wall. He punched him in the back as well. Mr. Charles Price is 80 years of age as well, as the information that I have. The bond recommendation in this particular case is for, I believe the bond recommendation is for $6,000 signature bond. We are asking for, through pretrial services, we would agree at a level 1, no further contact with Charles Price and stay away from that address and location. There has been contact with the victims and they do want him to stay away and have no contact at this time. No
All right.
alcohol, drugs, or weapons while out on bond.
Is Mr. Charles Price present?
Security, two different things. A signature bond, you
Oh,
sign it.
no. Hold on one second. I'm sounding for Mr. Charles Price or anyone. Okay, Mr. Price, I strongly suggest that you allow Ms. Kim to assist you, who has sufficient understanding of the laws of the state of Georgia. You may unintentionally say something that harms your case. The state is listening and will use anything you say against you. Do you still wish to represent yourself?
Still wish to represent myself because I know the law.
Okay, well, go ahead.
Defense. My dad, I was got some popcorn, got a drink, went up in
Okay, you're gonna start talking about the case. I think you should make legal arguments. What are your legal arguments today?
Self-defense. My dad got in my face, I pushed him, we grappled. Grappling is defense. He got on top, I tried to pull him
Okay,
off.
you realize that you might not be helping yourself right now, and Ms. Evans Battle is listening, can add other charges. I do not want to see that happen to you.
You don't understand the law. It's self-defense. You know what grappling is? Ever seen mixed martial arts? Somebody's attacking you, you try to control
I'm
them.
trying to help you, Mr. Price. I really think you should stop talking.
You legally have no clue what you're talking about. How long are you gonna judge?
Well, we're not gonna do that, but make your final legal arguments. Go ahead.
Self-defense. Grappling is self-defense. Assaulting somebody involves punching in the face, which can be self-defense if somebody's bigger than you. And if somebody's older than you, they'd be like your dad beating the shit out of you. And they're like, oh, he's
You're gonna
80.
use respectful language. You're not gonna do that. Go ahead.
Your dad assaulting you and punching you in the face, and you trying to defend yourself and saying, oh, you punch back, so he's old, it's assault. No, it's still legally self-defense. How long have you been a judge?
Is there anything else you'd like me to consider?
No, you gotta dismiss the whole case. It's unlawful detention.
That will not be happening today. Would you like to speak to the bond?
Unlawful, it's aggravated kidnapping by the cops. I shouldn't be here at all. You gave me a summons, I showed up, and you said.
Okay. Do you want to speak to your bond arguments or no? You know the law. Go ahead, speak about bond.
For you legally, because how long have you been a judge? What was your bar number before you became a judge?
Okay, that's entertaining. Mr. Price, do you wish to help yourself or are you finished? Go ahead, wrap yourself up. You finished, Mr. Price?
You know the law. What's your bar number? You can't be a judge without a bar number.
Okay, are you going to talk about your own case? Or you want to waste your time talking about me? We can waste my I'll happily read you my resume, but that's not relevant today. What would you like to tell me about your bond? Do you live in the state of Georgia? Do you have ties to the community?
It's serious crimes to do that. And then this would be violations under code of law, and then violations of constitutional rights, quite a few. And if these are not actually attorneys on here, then yeah, it becomes conspiracy against rights. Extremely serious offenses that can get you life in prison depending on what happens. Any lawyer would know that. Any judge would know that. So throw the whole thing out, I walk out the door. Otherwise, yeah, I'll be charging you with a federal conspiracy, among other things. And stop wasting my time and throw the whole thing out.
Is there anything else you'd like to tell me about the bond? I'm about to be finished. I'm about to rule. You finished?
You have a bond, and if you're not a judge, you can't.
Okay, defendant is going to receive an $8,000 signature bond at level 3 through pretrial services. He's going to take a 3-day anger awareness course. He is to have no further contact with the alleged victim in this case, and he is to stay away from that location at least 1,000 yards. He's to have no alcohol, no drugs, no weapons, and he will be reset further notice. Ms. Evans Battle, is there anything else that makes sense that we can listen to today? All right, best of luck to you, Mr. Price. Take care.
Your Honor, how many anger awareness classes did you say?
3. He's going to take 3.
Okay, thank you.
All right, best of luck to you, sir. That concludes your case. Who do we have next? I look forward to the federal conspiracy complaint.
All right, next we have 31, Mr. Reagan.
Mr. Reagan, good afternoon. Your case is 26 CR 000-434E. In this case, you're charged with obstruction. Do you understand your rights?
Yes.
Thank you, Mr. Howard.
28. You got to open petty theft out of Jacksonville, Florida. On probation out of Cobb. Aggravated assault wanted out of Cobb County. 2024 probation. 2024 trespass obstruction NOLO. 21 battery simple assault cruelty to children conviction. This was level 3.
Okay, thank you. Ms. Evans Battle.
Yes, Your Honor. On January the 19th, officers were investigating for the second time a call in reference to someone with a gun knocking on random doors of the hotel and threatening to shoot. They located Mr. Reagan coming out of a room with a book bag matching the description. The hotel's location is 5021 Old National Highway. The officer asked him what happened, and of course, he acted as if nothing had been going on. He was not involved. He walked away. She continued to ask him to stop. She asked him not to go into the room. He went into the room, barricaded himself in there for a period of time. Then he did at some point in time come out. She had other officers arrive as well. He came out without the book bag and stated that he was knocking on a female's room door by accident. There was a search that was incident to arrest. There was no weapon or contraband found on him, but there was a warrant already in place. There's also video showing his actions going back and forth at the hotel, making threats. And the person whose room he came out of, it was a female in the room. She left the location during the officer's investigation. We're asking for the bond is set at $5,000 surety. We would just ask that it remain the same and that he stay away from the 5021 Old National Highway location, no alcohol, drugs, and weapons while out on bond. Thank you.
All right, thank you. Ms. Kim?
Yes, Mr. Reagan is 35 years old, and Your Honor, he lost his parents recently, and he's been struggling emotionally and also residentially challenged. So that's why he's staying at hotel. He has a 3-year-old daughter, and we would like to request for a signature on bond through pre-trial level 3. He graduated from high school 2009, and he got nutrition certification from the Job Corps. And right now he is working as a musician. He does hip hop and he also does producing as well. He has a Cobb County hold. So even though he gets a signature but from here in Fulton County, he will be going to Cobb County. And also I want to clarify about 18 CR 0013670. I'm assuming these are NOD. Am I right, Miss?
Does anyone know? Are the other charges NOD'd?
Yes, this is the only charge he has for us.
Okay, so those 2018 cases are not on the record. Okay, no problem, Your Honor.
All right, defendant's gonna receive $1,000 surety bond, and he is to stay away from that location, have no alcohol, no drugs, no weapons. Is there anything additional?
Sure.
All right, best of luck to all parties. Who do we have next?
38, Mr. Thompson.
All right, we can't do that one. Can we take another position, please?
Number 3, Mr. Bell. What, they not gonna let me say no? Excuse me, Your Honor.
I don't think you should say yes. What's your question?
Please, just state something.
Very quickly.
How is it it's not obstruction? Because when the officer first approached me, I never knew she was looking for me. I was already going to my room. So, I mean, technically it's not obstruction because she never said stop. She never said freeze, never showed, no, nothing. I was already like going to my room.
Would you
So
like to confer with Miss Kim?
I mean, no, it's not obstruction. I'm in my room. And when the other officer, when he arrived, he asked me a clear question. It's not worth me sitting in jail when I got a child I gotta get back to. So no disrespect to the court at all. When the other officer, when the other officer arrived, he clearly just asked, "Do you have room here? Yes or no?" And I said yes. Now, past that, I mean, I was already at my room. Like it's no obstruction. Obstruction is if I ran from them. I didn't run from them. I was already in front of my door. So like that's it.
I'll take it into consideration. Okay, I'll think about it for the balance of the calendar. For right now, it'll stay as it is, but I will think about it. Okay.
Can I ask a question why we are not going to see the Thompson case?
No, please don't do that. We'll only be here longer, and it's not. I don't know. Please don't do that. The Thompson case is on the calendar, ma'am. Please hold. All right, everybody, we're gonna take a 2-minute break. I need a 2-minute break. We'll be right back.
Courtroom 2, can you check the chat for me, please?
All right, thank you all for your patience. I appreciate it greatly. We're going to proceed on position 3, Mr. Keyshawn Bell, 26 CR 000-420H, in which defendant is charged with 2 counts of battery family violence and 2 counts of simple battery family violence. Mr. Howard?
Fourth arrest, 2025 fraud, 21 obstruction dismissed, 2019 marijuana dismissed, level 1.
Thank you. Mrs. Sirocco?
Yes, Your Honor, I did see a giving false ID to law enforcement officer. That's specifically what the charge is there, out of Florida, 2025, filed February. So presumably that's still open. But this incident here took place May 19th of 2025 at 2794 Narren Court in Atlanta. Officers responded in reference to a physical altercation between a man and a woman. They had responded to that same address roughly 10 minutes before on another matter involving the defendant's brother, where in that encounter, the defendant, who is the son of Miss Jennifer O'Neill, was acting irate towards his mother and officers. There are several MH issues and potentially a diagnosis. Officers removed themselves from the scene to calm him down, and then officers came back to the location in reference to another call about the defendant having physically assaulted Miss O'Neill's girlfriend, Miss Aviance Webb, whom they made contact with. She who lives with her and the defendant at the residence. Um, she stated that he had attacked her. She sustained injuries to her, the right and left side of her face, swollen eyes, bruising on both cheeks, and blood coming from her bottom lip were observed by officers from the defendant punching and kicking her, as she reported. There's also surveillance video of the incident. We have spoken with the victim who confirmed the events in the warrant. She stated her lip is still a little messed up and that she's removed herself from the situation, is no longer in a relationship with the defendant's mother. She said she never lived at the home. When I'm looking at the report here, the address is, and that's what I have from the warrant as well, but the addresses from the report further confirm that they did live there. That's 2794 Narren Court Southwest address. So I'm not sure what the misunderstanding is there, but she said this was the first altercation with the defendant, but did state there have been other issues with the defendant and the defendant's brother, but she has no concerns since the incident. The state is recommending a signature bond through pretrial. With the severity of this, we are asking for 3 days anger awareness, social worker visit for MHET, potential housing. If he's on medication or currently receiving treatments already, we would ask you that he continue with that. We're asking for. We didn't hear back on whether. I'm assuming no concerns would mean no further violent contact would be fine, especially since she's moved out of the residence and is no longer dating Miss O'Neill. So the state will be asking for no further violent contact with Miss Webb, and no drugs, weapons, or alcohol while out on bond. That is all for the state. If we could sound for Miss Webb.
Is Miss Webb present and wishes to make a statement? Hearing none, Ms. Cook?
Miss Cook, you're muted.
You're muted, Ms. Cook, if you're speaking.
Thank you. I'm sorry. We're not opposed to the state's recommendation of a signature on bond. Mr. Bell is 24 years old. He's been in Georgia, is my understanding, for the last 8 years, I do believe. It is also my understanding that the complaining witness does not live at the incident location, as told to me by Mr. Bell. It's my understanding that he's currently unemployed. He graduated from high school back in 2020. There were some concerns as it relates to mental health, so we are not opposed to having a social worker visit him if at some point. No further violent contact with the victim is fine. It's my understanding that, like I said, he doesn't really have contact with her anyway, and that she doesn't live there. So that's what we'd be asking for the court.
All right, thank you. Defendant is going to receive a $4,000 signature bond through pretrial services at level 1. It'll be 1,000 on each count. He's to have no further violent contact with the alleged victim, have no alcohol, drugs, or weapons, and he is to interface with a social worker if it can be done prior to his release. And he's going to take the 1-day anger awareness course. Is there anything additional? All right, best of luck to you, sir. That concludes your case. Who do we have next? I'm sorry, what position is this? It's muted.
I'm sorry about that. Number 5, Mr. Brown.
This is Mr. Brown, number 5.
Yes, ma'am.
Okay, Mr. Brown, your case is 26 CR 000423F. In this case, you're charged with battery. You understand your rights?
Yes.
All right, Mr. Howard.
All right, hold on, somebody knocking. I got 10 adult on probation for ag assault out of Clayton County. 2 FTAs from last year, 1 from 2024, and some probations from 2024. This was level 3.
All right, thank you. Mr. Sirocco?
Yes, Judge, I saw the probation violations from 2024 and 2025, one from 2025 as well. FTAs from 2024 and 2025 also, 2 from 2025 specifically. And with respect to that ag assault out of Clayton County, that may well be a conviction by revocation of the First Offender Act. It's not quite clear, but in any case, concerning aspect to his history here. And he was just convicted of loiter prowl, willful obstruction, giving false info, and disorderly conduct out of Fulton this year. This incident here took place January 19th at 216 Peachtree Street in Atlanta. There was report of someone screaming out for help about a man seen hitting a woman. The officer observed the victim upon arrival, Miss Anna C.A., covered in blood on her face, her clothes, her belongings. She was being assisted by bystanders in the vicinity. The officer actually rendered aid on the spot due to the amount of blood that was coming out of her right eyebrow. She explained that she was walking off the train at Peachtree Center, MARTA station, when out of her peripheral view, a man ran up, proceeded to knock her down before repeatedly punching her in the face on the southbound platform. She did not know this man. And she's also, following the incident, was unable to open her right eye, subsequently taken to Grady Hospital due to the nature and severity of her injuries. The description she provided and helped to find the defendant. There were other witnesses as well who provided that description, and she identified him later as the individual who had attacked her. Also note that the defendant, when encountered, had blood marks on his right hand and on his pants. Now, this is, I mean, obviously there's a risk of failure to appear with recent FTAs from 2024 and 2025 that aggravated assault gives concern for reoffense as well. But I mean, this was a random attack on a random individual, poor woman out on the subway that did not know this man from Adam. So this is there is a huge risk to individuals in the community with this defendant and reoffending with other individuals that he does not know for no reason. The state is very, very concerned. So we are recommending that the $7,500 surety that is currently in place remains set. We are asking for 5 days anger awareness, social worker visit for BHET, no further contact with Anna CA, stay away from all MARTA premises and property, and no drugs, weapons, or alcohol while out on bond, Judge. If we could sound for Miss CA if she's online and wishes to speak.
All right, is that party present, Miss C or CA, perhaps? Spell it for us, Mr. Sirocco.
SEAY, Your Honor.
Okay. Is that party on the line and wishes to make a statement? We're sounding for Miss C or CA, perhaps. Okay, Miss Cook.
Mr. Brown is 21 years old. He's had based on his version of challenging upbringing, it's my understanding that he was or is employed at a tortilla factory in Atlanta. He states that he has some college at GSU. He does have diagnosed MH history. So we are in agreement with the social worker visit. I believe he had a traumatic incident that occurred previously while he was incarcerated at a different jurisdiction, and that probably contributes to his behavior. Your Honor, any amount of bond that you set in this case will be the equivalent of a no bond. He is residentially challenged as well. He is open to participating in any sort of programs if we were to find some for him. So we of course will be first asking the court for a signature bond, but if the court does not do that, a very low reasonable bond in this case.
All right, defendant is going to receive a $4,000 surety bond. He's to have no contact with the alleged victim, stay away from that location, have no alcohol, no drugs, no weapons. And as he is receiving a surety bond, he will be reset to all purpose on the 3rd of February. Is there anything additional from the state or from the defense?
No, Your Honor.
All right, best of luck to you, sir. I am going to ask for a social worker visit as well. All right, who do we have next?
Number 6, Mr. Burris.
First name cautious.
All right, Mr. Burris, your case is 26 CR 000424G. You're charged with 3 counts of criminal trespass, 1 count of stalking, and 1 count of disorderly conduct. Do you understand your rights today?
Yeah, I understand my rights, ma'am, but I don't understand my charges though. I just was told I was just charged with trespassing, ma'am. So what charges I have again, ma'am?
You have 3 counts of trespass, 1 count of stalking, and 1 count of disorderly conduct.
Is all of them felonies or misdemeanor?
These are misdemeanor charges. You understand your rights?
Yes, ma'am, yes, ma'am. And
Okay, let's proceed. Mr. Howard?
46 cycles. You got to open shoplifting 26 PR 00. It's a number missing, but it's an open PR case. It's 2 of them actually. I got to open possession of marijuana out of state court, suspended license, no insurance, seatbelt violation. On probation, possession of a firearm by convicted felon or felony first offender. I got 2 FTAs. I got 1 from 2022, 1 from 21. I got 2019 FTA, 2 of them. 2019 trespass conviction, level 3.
Okay. Thank you. Mr. Sirocco?
Thank you, Your Honor. I also saw receipt, possession, transport of firearm by convicted felon, conviction 2022, and felony fleeing and eluding and driving without a valid license 2019. That was a conviction as well. This series of incidents took place from January 12th through the 14th of this year at 2855 Jerome Road in South Fulton. Law enforcement originally responded to a vandalism call in reference to damage to property. They made contact with the victim, Miss Jessica Fox. She explained the defendant, who lives on her street, had been coming onto her property and damaging it. On Monday, January 12th, the defendant's 9 a.m. Ring camera activated, captured defendant walking through her carport area, entering the fenced-in portion of her backyard, throwing trash and other objects toward her trash cans and at her animals. 40 minutes later, same day, returned to the property wearing a face mask and armed with a sword, used the sword to cut down the Ring camera from the carport ceiling, damaging it, and then throwing the camera at her dog. Also caused damage to the carport garage door at that time. Uh, at 1 p.m., same day, returned again, continued to throw trash at her animals. And then later at 6:15 p.m., when the defendant had observed her, uh, he was standing under his carport while verbally assaulting her using profanity due to, excuse me. Then on January 13th, 9 a.m., defendant was walking up and down the street in front of her residence, appearing to watch her home. He then went to her back door and attempted to remove another camera. When she returned, home that day, she saw the defendant retrieving a sword from his vehicle and staring at her while repeatedly stabbing his door with the sword. Then, January 14th, the next day, 9 a.m., he then again entered her property, knocking over a trash can, scattering trash across her driveway. She is unsure if the defendant will, or she stated in the warrants that the defendant will attempt to harm her or her daughter. That is a concern of hers. And the officer observed camera footage substantiating what she'd said. With his failures to appear, there is a risk of failure to appear. I believe pretrial stated 22, 21, 2019. I mean, and this is just a concerning series of events over the several days. And we are concerned, as she is, at least from the warrant, as we have not spoken with her yet, for her safety, for her daughter's safety. The state is therefore asking for a $7,000 total surety bond, $5,000 on the stalking, and $500 on the remaining counts of criminal trespass and disorderly conduct. We are asking for a social worker visit for BHET, potentially MHET. No further contact with Jessica Fox. Stay away from 2855 Jerome Road in South Fulton. And if we could sound for Miss Fox at this time.
Okay. And before I do that, uh, hold on. And it was 7,000, and you had the 5,000 on the stalking, Mrs. Sirocco?
That's correct. That is the state's recommendation.
All right, Ms. Fox, if you'd like to make a statement, please raise your right hand. Are you in the store?
Yes, please.
Are you able to go somewhere else?
Hey,
Are you in a store, Ms.
yes,
Fox?
give me 1 second. I'm sorry. I was by myself.
Okay, you're glitching really badly, Ms. Fox. Say that again.
I'm sorry, I can hear you. What you say?
That's exactly what I was saying. We can't hear you. You're cutting in and out. Can you go to a different location?
Okay, can you hear
Very
me now?
quick, very quickly. Okay,
Can you hear me now?
I can. Please raise your right hand. I'm asking you to raise your right hand.
I'm raising my right hand.
Okay, we need to be able to see that. Can you hold the camera back? Thank you. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge?
Yes, I do, ma'am.
All right, what would you like to tell me?
Yes, I am very concerned about me and my daughter staying there, especially since we stay right next door to each other. I have taken out a TPO on the situation because my daughter comes home before I do for work, and sometimes she leaves after I do. So I am very worried about that.
Okay. Is there anything else you'd like to tell me?
It's just that this is very sporadic. Don't know what got into him to make him do this to my property and continue to do it. Just trying to figure out where I go next because I've been living there for over 10 years and never had a problem before.
Okay. I appreciate you coming to court making that statement, Ms. Fox. Thank you. Ms. Cook,
Thank you.
please. Ms. Cook, please proceed.
Mr. Burris is 41 years old. He's been in the Metro Atlanta area for the last 13 years, I do believe. It's my understanding that he was working at Jamaican as a cook. He does have a GED that he obtained in 2004, as well as some college per him where he was studying computer networking. He did have a traumatic life event previously where he was shot in the head in Louisiana, which contributed to some of his issues. Per him, he did serve in the Marine Corps for 1 year. He does have, as a result of that, some mental health related issues where he does take medication, but not currently. He does have 2 children, a daughter, a 12-year-old daughter, a 10-year-old son. As it relates to Miss Fox, they are neighbors, they're next door neighbors. It's my understanding that recently Mr. Bird's house was burglarized. And this series of events may have been a result of his belief that she had something to do with that. As far he does still, even though he is employed, he does have a limited income and would still qualify for our services once he is released from custody. So for those reasons, Your Honor, we are asking, obviously, first we will ask for a signature on bond. If the court is not inclined to do that based on his criminal history and the facts of the case, a very reasonable bond in this case.
Okay, defendant is going to receive a $4,500 surety bond broken down as follows: 500 count 1, 500 count 2, 500 count 3, 500 count 4, and 2,500 on count 5. He is to stay away from the alleged victim's residence. I'm not going to exclude him from his own home, but he needs to go directly inside and stay away from hers. He's to have absolutely no contact with Ms. Fox or her minor child. He will be reset to state all purpose. He is to have no alcohol, no drugs, no weapons. Is there anything additional from the state or from the defense as it pertains to this case?
No, Your Honor.
All right.
Noted.
Best of luck to you, sir. That concludes your case for today. Who do we have next?
Number 8, Mr. Colton.
Mr. Colton, your case is 26 CR 000-427E. You're charged with possession of marijuana, obstruction, simple battery against an officer, and fare evasion. You understand your rights today,
I am.
Mr. Howard?
17, 2024 suspended license. 2019 disorderly conduct, obstruction, reckless conduct, arrest. 2018 criminal damage in the second, obstruction, first offender. 2014 disorderly conduct conviction. And a 2013 failure to appear of level 2.
Okay. After this case, Ms. Bridgewater, will you please give me a call? I noticed something. Mr. Sirocco, please proceed.
Yes, Your Honor. I also found there's a dormant bench warrant case it's docketed under 19 CR 009204E, and that is for disorderly conduct and obstruction. Also saw, at least with the most recent criminal history run, that he was wanted out of Douglasville for assault and battery from October of this year. The state's just briefly, this was January 19th of this year at 680 Lee Street in Atlanta. The officer observed the defendant enter the MARTA station there without paying the required $2.50 fare. I believe this is Lindbergh Station. Officer told the defendant to place his arms behind his back. He refused. Defendant also attempted to flee. While officers were actively trying to detain him, he had pushed one of the officers during that encounter, and a search incident to arrest revealed a small bag of marijuana that was in the defendant's sling bag that he had on his person. I also see FTAs from 2017 and 2015, as well as 2013. The state's recommendation here, currently bond is set at $4,000 total surety. We're recommending a $1,500 split bond, $1,000 surety on the civil battery against a law enforcement officer, 500 surety on the obstruction, and signature bond through the jail for the marijuana and fare evasion charges. We would ask for a social worker visit if necessary for housing and resources. Stay away from MARTA premises and property in accordance with any active suspensions, and no drugs, weapons, or alcohol while out on bond.
All right, thank you, Ms. Cook.
Mr. Colton is 38 years old. He's been in Georgia all his life. It's my understanding that he did. He's completed some college. He did serve 4 years in the Marine Corps, 1 year in Iraq, active duty. He was employed at Defender, which is an event setup as an event setup specialist. However, and he's been there for about a year. However, he believes that since he was scheduled to work and didn't call and didn't show, the job is likely he's likely going to be terminated from that job. It's my understanding, and I did not verify this, that he does have a pending felony where he received a $10,000 bond that he's very unlikely to make. He said that he's basically he sleeps in his car. He's a homeless vet. He does have a son who's 8 years old. He does have a good mailing address though, where that he shares with the mother of his child. So he does have a way of getting notices for court. We will be asking the court based on the charges. I do understand that he does have a history. Still for a signature on bond on all these charges, and if not that, of reasonable bond in this matter.
Okay. So defendant is going to receive a split bond as follows: $1,000 signature bond through the jail on the possession of marijuana, $500 obstruction on the 500 on the obstruction. That'll be a surety bond. $1,000 surety bond on the battery against the officer, and $1,000 SOB through the jail. So he's only got to make bond for $1,500. He's to comply with any active MARTA suspensions, have no alcohol, no drugs, no weapons, and he will be reset to state all purpose on the 3rd of February. Is there anything additional from the state or from the defense?
None, Your Honor.
All right, Ms. Bridgewater, will you please give me a quick call? We can go ahead and start bring up the next person though. It should be very.
All right, let's got 13, Mr. Dudley.
Okay, thank you all for your patience again. Mr. Dudley, your case is 26 CR 0000429E. You're charged with simple battery family violence. You understand your rights? All right, Mr. Howard.
28, 2023 terrorist threats, harassment phone call, arrest, 2021 battery DV arrest, 2021 obstruction conviction, 2012 terrorist threats conviction, 2010 simple assault conviction. Level 3.
Mrs. Sarasha?
Thank you, Your Honor. There were a number of other convictions as well. They're not all entirely relevant, but Your Honor should know they're 1, 2, 3, 4, 5, 6, 7 at least. This incident here took place January 3rd, 2026. This was at 3136 Martin Luther King Jr. Drive in Atlanta. That's a convenience store. I don't have the name of that convenience store, but that's not entirely relevant right now. Miss Luisa Cortez is the victim. She explained that the defendant, who is her ex-husband, had assaulted her. She'd been separated from the defendant for 2 years, and the defendant will text her about wanting to commit suicide, sending pictures and videos of things alluding to that, I'll say, if she did not take him back or date him again. So concerning outright. The defendant walked up to her on this date here, and this was while she was in the convenience store with her niece. He approached her, pulled her hair, started pushing her against the counter of the convenience store. She had given her phone to the clerk on duty to record what was happening, and the niece took videos as well, just in case anything happened to her. She also stated the defendant has people that watch her, or at least to her belief. She explained she'd been married to the defendant for about 5 years, and throughout their marriage, she experienced his violent behavior that ultimately led to her separation from him. Now that he has resurfaced after 2 years, she is afraid that he intends to take her life. She's been attacked at least 10 times. She recounted to the officers throughout their marriage, and she confirmed the defendant's identity. With the defendant's history, the presumably open case out of Clayton, felony terroristic threats and acts and harassing phone calls, as well as that 2021 battery case out of Clayton, um, and as well as his prior convictions, some of which are violent in nature. The state is recommending $6,000 total surety out of concern for the victim's safety here. We are recommending 3,000 surety for each charge, as well as FFIB on account of his history and her explanation to the officers that this is one of almost going on a dozen incidents with the defendant where he's been violent towards her. No further contact with Luisa Cortez. Stay away from her address. I don't want to provide that stay away from wherever she resides. I can send that to the court, but
Fine, yes.
yeah. And no drugs, weapons, or alcohol while out on bond. That is all for this case. If we could just sound for Ms. Cortez.
Is Ms. Cortez present and wishes to make a statement? Hearing and seeing none, Ms. Cook.
Mr. Dudley is 50 years old. He's resided in Georgia all of his life. He is employed at through temp service. He's been doing that for the last 3 years. He graduated, it's my understanding he's a graduate from Douglas High School in the mid 1990s. He does not have any issues with not having any contact with Miss Cortez. It's my understanding that they're going through a divorce at this time. Even with him being employed, he still is financially challenged. And so we would be asking the court, if not a signature bond, a very low bond, less than $1,000, nothing further.
All right, defendant is going to receive a $1,500 surety bond, $750 on each count. He's to have no contact with Ms. Cortez and stay away from wherever she resides. He's to have no alcohol, no drugs or weapons, and he will be reset to all purpose on February 3rd. Is there anything additional?
Nothing from the state, Your Honor.
All right, best of luck to you, sir. That concludes your case for today. Who do we have next?
17, Mr. Harris.
All right, Mr. Harris, good afternoon. Your case is 26 CR 0000432A. In this case, you're charged with fair evasion and criminal trespass. You understand, right? All right, Mr. Howard.
7. He got an open case out of Houston. Burglary of vehicles. Open trespass out of from Marta. On probation for fair evasion trespass. It's 25 CR 006-373A. On probation out of Columbia County for forgery. 2025 trespass no low. This was level 3.
Thank you. Mr. Siraka.
Yes, Judge, he is with this case from January 19th, 2026 at the Lindbergh MARTA station. He was observed pushing through the fare gate without paying the fee, and it was discovered upon suspension check that he had been permanently banned as of October 14th and effective October 14th from MARTA premises and property. He's with this in violation of his existing bond. I did not write down the case number, but it was he was convicted last year and was as part of his probation. Has to stay away from all MARTA locations in compliance with a suspension. So he's in violation of that, and it looks like wanted out of Houston for failure to appear. With the flight risk, failure to appear, risk of that, and with his violation of bond, the state is recommending that the $2,000 total surety that is currently in place, it's $1,000 each, that remains set. Stay away from all MARTA premises and property, and no drugs, weapons, or alcohol while out on bond.
All right, Ms. Cook.
Mr. Harris is 24 years old. My understanding that he's lived in Georgia all of his life. I do understand just that he has an open matter in another jurisdiction. However, he's currently unemployed. He does have a high school education. So any amount of bond that you set, if it's not a signature bond or a UJR, would be the equivalent of a no bond for him. So for those reasons, Your Honor, we're asking for a signature bond, and if not, that a very reasonable bond in this case.
Okay, defendant's going to receive a $10 cash bond, $5 on each count. He's to comply with all current MARTA restrictions, have no alcohol, drugs, or weapons. Is there anything additional?
Nothing further. Thank you.
All right, best of luck to you, Mr. Harris. Who do we have next?
18, Mr. Hurd.
Mr. Hurd, good afternoon. Your case is 26 CR 000433G. In this case, you're charged with battery, family violence, and simple battery, family violence. You understand your rights? All right, Mr. Howard.
6. You got open battery DV. Possession of a controlled substance. It's 25 PI 004897. On probation, possession of cocaine and simple battery. I saw a 2019 burglary that was dismissed. Level 3.
Okay. Mr. Sirocco?
Yes, Judge. I did see a First Offender Act deferred possession of cocaine, 2023, where there was a murder charge that was null prost and a First Offender Act deferred simple battery, three counts of that, and possession of cocaine, where involuntary manslaughter charges were null prost. And with respect to that open case, the 25 PI 004897, that is battery, family violence against also the controlled substance charge, but battery, family violence against the same victim. For similar facts here, he was hitting his child, resulting in bleeding, scratches, and busted lip, as well as head pain and choking him, causing him to almost black out. This incident here took place January 18th, 2026 at 765 McDaniel Street, Southwest in Atlanta. Law enforcement responded to the location, made contact with the victim, juvenile AH, who explained to the defendant his father had attacked him, placed hands around his neck, and officers observed marks from that. We did speak with the mother of the victim, Miss Georgiana Shepard. She states they all live together, and there are some disciplinary issues with the child. The incident started with the victim and his brother fighting. She was not at home during the incident, however. Excuse me. She stated that she did receive a call on FaceTime where she could hear the victim screaming, saying he could not breathe and to get off him. Her mother, Miss Shepard's mother, came and hit the defendant with her cane, and that is when the defendant got up off of the victim. In this case, we've not spoken to the victim himself, but Miss Shepard is asking for no further violent contact and for the defendant to return home. I I will say that's been tried with respect to the open case where he was ordered to have no further violent contact with the same victim and not successful bond condition there. He needs to have no further contact. So we'll be asking for that. We're very concerned, given the facts here, as well as the similarity to the open felony case. We are therefore asking for a $6,500 total surety, $5,000 on the battery family violence, and $1,500 on the simple battery family violence. We are recommending FFIB. We think that's more than appropriate here, as well as no further contact with juvenile AH. Stay away from 765 McDaniel Street Southwest in Atlanta, and no drugs, weapons, or alcohol while out on bond. This may be a possible transfer for aggravated assault strangulation, Judge. But that is yet to be determined. We will, of course, apprise the court in defense of that as this progresses. If we could sound for Miss Shepherd on behalf of her son here.
All right, is Ms. Shepherd present? I'm sounding for Ms. Shepherd. You're in none, Ms. Cook.
Thank you, Your Honor. Mr. Hurd is 40 years old. He's been in Georgia all of his life. He is employed with area wide protection, which he does traffic control, construction related. He did obtain a GED in 2004. He does have two children, a 16-year-old and a 13-year-old. He denies the allegations as alleged, Your Honor. He has a different version of what occurred. I will just like to add on his behalf that it is from his perspective, his two younger sons, the 16 and 13, were fighting each other. He did intervene. When he intervened, it's my understanding that the 16-year-old then went to grab a knife, and that he acted to try to ensure that the knife, it's my understanding the 16-year-old was just swinging the knife, endangering everyone around. And so he acted to ensure that no one was harmed. He did mention that he understands that his main concern was that he is currently out on bond for this. It's my understanding that maybe DFACS has possibly been involved and reached out, and they gave some advice, possibly with the 16-year-old being determined as an unruly child. There are some behavior issues there. He does. I mean, I understand he lives there, and I understand the state's concerned. But he is financially, he does provide for the home. He and Miss Shepherd have another child there. We would object to the FFIB at this time, especially given I guess his version and how it occurred. And maybe if he is convicted, then obviously that would be something a condition that he would be sentenced to upon conviction. We would ask the court to do no further violent contact with child AH, to still allow him to return home. Based on, I guess, what the state communicated to the court, Ms. Shepherd does want him to return home and to be with the children. So we would want that. Even though he does work, it's still a financial strain to be able to afford all of the necessities. So we would be asking for a very reasonable low bond in this matter.
Right. Defendant's gonna receive $1,000 surety bond, 500 on each count. He is to stay away from that location. He can return one time with a member of law enforcement to get any items he may require, and he's to have no further contact with the alleged victim in this case. For now, again, this can be revisited at a later date, but at this time, that is what the ruling will be. He's to have no alcohol, no drugs, no weapons, and the case will be reset to state all purpose on the 3rd, whereby the case can be revisited. Is there anything additional at this time?
No, Your Honor.
All right, best of luck to you, sir. Who do we have next?
Position 23.
Mr. Jones, your case is 26 CR 0000411J. In this case, you're charged with simple battery, family violence, and simple assault, family violence. You understand your rights? All right, Mr. Howard.
10. 2024 accessory or compound felony. That looks like out of South Dakota. 2024 domestic assault conviction. 22 simple assault, 2 counts conviction. 2019 assault battery dismissed. Level 1.
Okay. Ms. Evans Battle.
Yes, on December the 26th of 2025, the officers went to 3000 Old Alabama Road at Johns Creek, which is a wing stop, and the employment of the victim. Her name is Nazara, Nasaira Mills. She indicated that she and Mr. Jones, who was her boyfriend at the time, accused her of having a relationship, inappropriate relationship in his mind with another female, and he choked her while she was at a hotel. She was able to get away and or break away from the situation because they were living in the hotel. So she broke away from the situation, and he was taking her to work at the Wingstop. They argued the whole time that they were on the way to the job. She indicated that she was getting out of the vehicle. He went over and pulled her out and hit her in the face with his fist. There was a witness of the incident who provided information to the officer, as well as when she attempted to walk away and was walking towards her job. He suddenly got in the car, accelerated, and almost hit her, which it appeared to be, in her mind, intentional. He is only charged with a simple battery and simple assault at this time. The state's recommendation is for a $2,500 bond. As to each count, that would be a $5,000 surety. It's my understanding that there is an open PI case that just came in regarding the January 4th incidents in which she is the victim. So we would ask that the court provide that bond, that there's no alcohol, drugs, or weapons while out on bond, that he stay away from Ms. Mills as well as any place that she is, her work, her house, or wherever she's located. Thank you, Your Honor.
Is Ms. Mills present and wishes to make a statement? Hearing none, Ms. Kim.
7 years old, and he moved to Atlanta, Georgia this January 2026 because most of his family members are here in Georgia. His grandmother, mother, son, ex cousins, and everybody around his relatives, they all reside here. And he accomplished GED 2004. After that, he became a certified pharmacy tech. Right now, he's working as an assistant manager for Dollar General. He's gainfully employed, having a strong ties into the community. Has 3 children, 18, 10, and 4. We would like to request for signature on bond through a pretrial level 1. He claims that that hotel, he does not live there anymore. So he has no objection to stay away from that location, 1950 Rock Hill. And I believe they don't have any contact anymore. So no contact is also okay with my client.
All right, defendant is going to receive a $1,500 surety bond, 1,000 on count 1, 500 on count 2. He is to have no contact with Miss Mills and stay away from wherever she resides. Have no alcohol, no drugs, no weapons, and he's going to state all purpose on February 3rd. Best of luck to you, Mr. Jones. That concludes your case for today. Who do we have next?
Edition 28.
Still wait.
All right. All right, good afternoon, Mr. Palmer. Your case is 26 CR 0000425C. You're charged with 2 counts of simple assault, family violence. You understand your rights?
No.
All right, thank you. Mr. Howard?
First.
All right, thank you. Ms. Evans-Spano?
Yes, Your Honor. This occurred at 1009 Windridge Drive in Sandy Springs. The victims in the case are Tanaya Palmer and Shania Palmer. There was a verbal dispute between the siblings, and he took some pepper spray. They were in a closed room in the bedroom, and he sprayed the spray at them. They had also indicated that they were fearful of him as well, because there were some medical concerns. It's my understanding is that we've had opportunity to speak with the victims in the case. And he's been released from the hospital. This happened back in September. And so he is living with them. Our bond recommendation is for a $2,500. Well, it's actually for a $5,000 signature bond through pretrial services, level 1, no further violent contact with Tanaya and Shania Palmer. As well, we would like at least 3 anger awareness classes to take place for the purpose of starting his, where we'll have an offer of pretrial diversion in this particular case. Nothing further, Your Honor.
All right, Ms. Palmer, I see you on the line. You're not required to make a statement, but if you wish to, please turn your camera on quickly and raise your right hand. All right, while she's working that
I'm
out,
sorry, give me 1 second. I'm trying to figure out how to do it.
please hurry. Please hurry. All right, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
I do.
All right, what would you like to tell me?
We never stated that we was scared for him to come back to the home. We actually said it was fine for him to come back. We just stated that we think that he would need a little therapy, especially
Don't say anything if it's medical, okay? Don't mention any sensitive medical information, but go ahead. Please continue.
We did say that we wasn't scared of him and that he could come back to the home.
Okay, understood. Thank you, Ms. Palmer. I appreciate you coming to court to make that statement. Ms. Kim, do you object to a signature bond at level 1 with no further violent contact and 1 anger awareness course?
No objection, Your Honor.
All right, defendant is going to receive a $3,000 signature bond at level 1 through pretrial services. It'll be $1,500 on each count for the total of $3,000. He's to have no further violent contact with either of the Miss Palmers and have no alcohol, drugs, weapons. He is going to take the 1-day anger awareness course. I am going to sound for Miss Shania Palmer. Is Miss Shania Palmer present? I know that we spoke with Tanaya, but is Miss Shania Palmer present? Wishes to make a statement. All right, hearing none, best of luck to you, sir. That concludes your case for today. Who do we have next?
33, Mr. Ricks.
All right, good afternoon, Mr. Ricks. Your case is 26 CR 0000455F. You're charged with battery, family violence, and cruelty to children in the third. Do you understand your rights today? Is that a yes? All right, thank you so much. Mr. Howard?
27, 2022 probation, 21 failure to appear, and a obstruction conviction. This was level 3.
I'm sorry, what was the last one?
Obstruction conviction.
What year was that?
Oh,
Was
the
this? Yeah,
22.
last conviction. Okay. Thank you. Ms. Evans Battle?
Yes, we had FTAs from 2022 and 2023, as well as the violations of probation from 2022 and 2023, and a whole host of other offenses. We are, in this particular case, it occurred at 8028 Gables Lane in Sandy Springs. Janiyah Thompson is the victim. Her first name is spelled J-E apostrophe A-N-A. There was an argument between the parties, and she is the mother of his child. He grabbed her by the jacket. They were at the car, and I believe it's a truck actually, but they were there, and he grabbed her by the jacket around her neck. at some point in time, he pushed her inside the car, got on top of her, and was strangling her. He struck her in the face. There were multiple scratches around her neck and cuts to her ear, and she was bleeding. This occurred in front of their child as well. And she did report that she did report that she could not breathe, that she was having difficulty speaking during this particular time. We have sought felony transfer has been made in this case. A request for transfer has been made in this case, given his history and the significant as the charges are. We're asking for a $5,000 surety as to each count. No further contact with Janaea Thompson, and that he stay away from the 8028 Gables Lane, Sandy Springs address, and that if the court is inclined to give visitation, that it would be a third-party visitation transfer between the parties as well. No alcohol, drugs, or weapons, no firearms while out on bond. Thank you.
All right, Ms. Thompson, I see you on the line. If you wish to make a statement, please turn on your camera and raise your right hand, but statements are not required. All right, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes,
All right, what would you like to tell me?
just that I do agree with the third party being present for visitation.
Okay.
And
Is there
that's all.
anything else you'd like to make? Are you have concerns for your safety? And do you wish to have contact with the defendant?
No, no contact, no excessive calls or harassment, please.
Okay. I do appreciate you coming to court to make that statement. All right.
Nice, thank you.
Thank you. All right, Miss Kim, please proceed.
Yes, Your Honor, we have no objection to stay away and no further contact as long as he gets third transfer for his children. And one-time law enforcement officer escorted visit to retrieve his personal belongings. He is 37 years old, born and raised here in Georgia. And Your Honor, he does have two children, 2 years and 11 years old. And he is willing to do co-parenting. However, no contact. He does not have any objection. He graduated from high school 2007, and then he went to Auburn College and Kansas University. So he's done about 3 years of college education, even though he didn't get his bachelor's degree. He has been working really hard. Right now, he does have a job, but that job has an 80 days probation period. So if he doesn't get signature on bond and get out of the jail, he may lose his job. So we would like to request for signature on bond, pretrial level 3. Thank you.
Okay. Defendant is going to receive a $1,500 surety bond, 1,000 on count 1 and 500 on count 2. He's to have no contact whatsoever with the alleged victim in this case. He can contact her through a third party to arrange transfer of the children. He can have a one-time law enforcement escort return to the location to get any items. Other than that, he must stay away from that location. He's to have no alcohol, no drugs or weapons, and he's going to all purpose on February 3rd. Is there anything additional from the state or from the defense as it pertains to this case?
Nothing further from defense, Your Honor.
All right. Best of luck to you, sir. That concludes your case at this point.
Yeah, it's come on. That's all right.
Ms. Bridgewater, will you give me another quick call very briefly?
Thompson.
I'm going to take a very brief hold. Ms. Bridgewater, please call me.
Your Honor.
Here.
Probably better make a copy of it now.
Okay, we're ready to proceed, but after consideration by the court, I'm changing number 31 to a $5 cash bond with all the same conditions. That will be Mr. Reagan. All right. Who do we have next? Courtroom 2 is muted.
Your Honor, we would like to request waiving sound.
Is the courtroom completely clear?
Yes, and also stopping the YouTube.
I
live.
will. I will in a second. What happened to number 7?
Oh, he bonded out, Your Honor.
Okay.
I think 16 and 20 bonded out as well.
16 bonded out.
Yes, man. I think and 20 as well.
Okay. Give me one moment. And what happened to 25? Same announcement, bonded out?
Which one's 25 again?
Edward Mills,
Oh, he's gonna be a reset.
medical or MH?
Yeah, both.
Which, which one is it more? Refuse to come out or?
Yeah, MH.
Okay. It doesn't seem like it matters, but it does. Okay. All right. And we're on 38 now. Okay.